Good evening. I'd like to open the Deerfield Planning Board on February 20th, 2018, 7 o'clock, 8 past 7. Here at the Town Hall in Deerfield, the agenda for tonight is to review any minutes if we have it, to review mail, and then to review a draft zoning bylaw for the cultivation and processing, product manufacturing, and retail sale of marijuana in Deerfield, and then to hopefully schedule a public hearing. Then we'll look at any other business not reasonably anticipated, 48 hours to the posting of this meeting. We'll set a date for our next meeting, and we'll adjourn. Any additions or issues with the agenda?
Do you want to ask about the
Yes. So we're good with that agenda?
Yes.
I'd like to, before I begin, we have some guests from the University of Massachusetts who would actually like to sort of make a quick announcement about what we're going to talk about tonight. So, James?
Thank you, Chairman. I
Yeah.
appreciate the
Actually, if you can speak into one of the mics. It's not just for the people here, but also for
Very
TV.
good.
Yeah.
I'd like to thank the Chairman and the Planning Board for allowing us the opportunity to be here tonight with you. My name is James Sullivan. I'm a graduate student at the University of Massachusetts Amherst in the School of Public Policy and Administration. At the rear of the room, I have my two partners, Toby Armstrong and Madeline Neal. Three of us are working together to hopefully, and with the town administrator, Wendy of Deerfield, to understand better the legalization of marijuana and cannabis in the state of Massachusetts and how it's going to affect specifically the town of Deerfield. We're looking at comparable towns in Washington and Colorado where marijuana, cannabis has been legal for a little over 5 years now. We're going to be conducting interviews soon with individuals from those comparable communities based on demographics, size, geographically that is, to Deerfield, to draw a comparative sample of people from education, from law enforcement, and from town government so that we can address concerns by way of education and how this may affect youth, by way of how this may affect crime in the street, and by way of this how it may affect economics, tax revenue, things like that, and then just to better understand general perceptions about pre-implementation and post-implementation of legalization of cannabis so that we may be able to provide a deliverable product to the town of Deerfield prior to the upcoming election here in May. We have our project due May 1st, May 2nd, so it seems like a fitting timeline so that we can have a deliverable product ready for all of you. What we're asking tonight is, and I have here with me, and you see simply a sign-up sheet, and what we're asking for is to, we're hoping to better understand the attitudes of and opinions of the townspeople. And we're looking to conduct a survey. We have created an online survey that's completely anonymous, and we're asking that if you'd be willing, we're going to pass this around to people in the audience, be willing to put down an email address that we may be able to reach out to you at and send you a link where you could go and take the survey or not take the survey. Again, providing your email tonight does not lock you into anything. It's completely anonymous, but we'd certainly appreciate your opinions, your time, and thank you.
All right, so I just want to make it clear. So this has nothing to do with the planning board, but it's
No.
It's a graduate project,
Yes.
I guess, and that you might also, you said you might visit the transfer station to try to reach out to more people
That's
who might
correct.
not be here tonight.
We're hoping to work with Kevin Scarborough from the transfer from the superintendent's office here to work at the transfer station to possibly set up maybe a table and chair to solicit email addresses in much the same manner we're doing tonight to get the wider opinions of townspeople so that we can provide a wider cross-section of opinions.
Good.
Do you have a business card?
As a matter of fact, I'm embarrassed to
If you
say
do,
I don't.
just give it to me before you leave. That's all.
I will. I will. Thank
With
you,
your
Mr.
other
Howell.
guys too. Yeah.
Very good.
Thank you.
And thank you for your time.
Sure.
Thank you.
Please.
So we don't have minutes from the previous meeting, and the previous meeting did, we talked a lot about the zoning bylaws for the cultivation of marijuana and other things, and a lot of that, what we came up with last meeting, we kind of talked to our town council about and to draft some proposed bylaws. So I think in the absence of minutes, we'll use that as our guide tonight, and we'll get the minutes for the next meeting. So it's not, we've had a lot of comments, so we definitely always want to take comments from the public, but tonight I think we want to start with our town council, who has drafted some proposed bylaws that eventually we want to get, have the public hearing, and then have on the warrant for the town meeting, which comes up in April. So does that sound like a way to start? Adam, you want to, and anybody who does speak, and we will, people can speak, but I've been asked to make sure you speak into the microphones, otherwise there's a lot of people out watching this and they don't get to hear anything, so appreciate that. So thank you for coming tonight.
Thank you, Mr. Chairman, members of the board. You
So
have copies of...
We received a draft copy. Many of us haven't had a chance to review it. So should we walk through it, or do you want to give us an overview of it first? And did people in the audience, were there enough copies that people?
I believe there are.
And
Yes,
there's
Pat was
actually
kind enough to make additional copies, so I think that there are a sufficient number to go around. I do think it would make sense to maybe briefly provide a bit of an overview and then walk through section by section, not necessarily reading everything verbatim, section by section, the amendments that are proposed. When we met a couple of weeks ago, certainly it was my intention to try and get something together and circulate it well in advance of tonight's meeting, but as I had anticipated, it was quite the undertaking, and there's a few reasons for that. The first is, I think it's important the board recognize, and I think you probably do, the licensing schemes that exist. So about 5 years ago, the act regulating the humanitarian use of marijuana, medical marijuana, was adopted by the legislature. And many municipalities, Deerfield included, adopted some form of regulation for medical marijuana facilities. You adopted an overlay district and created a new section of your bylaw. Pat Smith assisted in preparing that bylaw amendment. I had reviewed it at the time, and that document was, that amendment was adopted at town meeting. That creates an overlay district for medical marijuana only and applies to medical marijuana only. As you now know, we have adult use or recreational marijuana that has been legalized in the Commonwealth. And so we have the act itself, which was adopted via a referendum vote back in November of 2016. We have amendments to that act that were adopted in the summer of 2017 by the legislature. They recodified and revised substantially the legislation that had been adopted by the voters. And now we recently have regulations from the Cannabis Control Commission, which was created pursuant to the new legislation. But those regulations are in draft form only. And in fact, when I was before you a couple of weeks ago, it was in the midst of a series of public hearings that were underway, some of which were here in Western Massachusetts, to consider comments on those draft regulations, which have not yet been formalized. They're due to be formalized, I believe, in mid-March. So it's in the midst of all of this that we're working to create new zoning for recreational marijuana. So I give you that background in part because one thing that we had discussed, and you'll see what I propose is somewhat different than what had been discussed, but I've had an opportunity to do a bit more research over the past couple of weeks in light of what the board said, to speak to my colleagues and some others who have worked in drafting marijuana legislation in municipalities for town meeting adoption or for city council adoption. And there's a concern that the medical marijuana framework is not extinguished by virtue of the fact that there is now an allowance for adult use, recreational marijuana. There is a process that will take effect at the end of the calendar year, December 31st of 2018, when the Department of Public Health, which is currently overseeing the medical use of marijuana, will shift that responsibility to the Cannabis Control Commission such that the CCC will operate both to regulate and review medical marijuana and regulate and review adult use or recreational marijuana. But that hasn't occurred yet, and in fact, there will need to be new regulations that address medical marijuana at such time as the CCC takes control over that program. For the short term, I imagine they will utilize DPH regulations, which are in existence, but again, the legislation provides that they will adopt regulations to address medical marijuana. So there is a concern, I'll call it a risk, and I don't know how real it is or whether it's just us lawyers sort of over-lawyering the problem. But there's a risk that if you were to eliminate the medical marijuana overlay district altogether and create a new district for marijuana establishments, capital M, capital E, as defined in the new legislation for recreational use marijuana, that if you had a facility interested in cultivating or dispensing medical marijuana, that there'd be no regulation in place for that particular use until such time as in early 2018, the Cannabis Control Commission takes control of that program. So what I proposed in the document that you have before you is sort of a...
Early in 2018 or?
Early in 2019, that's correct. December 31st, 2018 would be the date on which the control officially shifts from the DPH to the Cannabis Control Commission. So what I proposed here, rather than an outright elimination of the medical marijuana overlay district, is maintaining that framework as it currently exists in your bylaw. I thought about trying to incorporate it into what you've asked me to draft for recreational marijuana, but then I said, well, gosh, now I'm going to have to come back to town in early 2019 and try to defragment this new zoning I've created to eliminate the references to medical if in 2019 they've become combined. So I said, how can I do this in such a way that I'm making as few amendments as possible to the existing medical marijuana framework in your bylaw, creating a new framework for recreational, and then if in the future, as anticipated, they all become under the same umbrella, we can simply eliminate the medical marijuana overlay district. And so that's how I've structured the zoning that you have before you. I've maintained to the extent possible the existing overlay district for medical marijuana, but then I borrowed from it for purposes of creating a new self-contained bylaw that will address recreational use marijuana. So the article itself is divided into several different items. I think if we walk through them, you'll have a better sense and understanding as to what I'm describing. So a few of these are relatively simple, a few are far more complex. The first one, item 1, is simply deleting the term medical marijuana overlay district from the list of districts and replacing it with the term marijuana overlay district. I'm using a broader term because this overlay district is going to be utilized to some extent for both medical use marijuana and adult use or recreational use marijuana. So simply changing the name.
Could I ask you to just pause there? Tonight, I should have said this at the beginning, everybody got an updated
Yes.
zoning bylaw?
Chapter
Right.
179.
Chapter 179, so actually, does everybody get one of them?
Yep.
Because actually, we can refer to this, because what Adam's talking about is, he's going in and changing words that are in this, and
Dick doesn't have a copy of that, or
Who needs one?
Max,
it's right down the corner there, on the corner of the table.
the small,
No, the small one,
Yeah.
there's some more of those somewhere.
yeah, he's got it.
Oh, okay. Have you got the 179 too, Max?
Yes.
Okay.
So we're in 121, which is where we have, that's just the beginning of our use regulations, yeah?
This is starting on what, 121 you said? 2100?
21.
2100,
Yeah.
yeah.
What page is that on, just out of curiosity? 197, 179.3?
Yep.
Okay.
So that's the first of the modifications, which is labeled as item 1 in the zoning amendment article. Item 2 are modifications to your table of use regulations. And
So just one other question I do have is now, is there a, so part of this is going to be for the retail part of it, part of it's going to be for the cultivation, and then the third one is manufacturing, right?
it's going to get even more complex than that. And let me explain.
Okay.
So I know that the planning board is certainly used to, maybe some members of the public aren't, seeing zoning articles in this format. But generally, the way that an article is structured, particularly if you're making modifications to a variety of different sections and subsections within a zoning bylaw, is you divide the article into different items, and then usually the items are chronological. They begin with the earlier sections of the bylaw and work toward the later sections.
Okay.
What it makes for is somewhat of a disjointed reading, because early on you're making modifications to the naming of districts and the table of use regulations, but some of the terminology you're using is not even defined until you get into the real substance, the real meat of the bylaw, which is a couple of pages later. So we'll get there, but absolutely we're going to define the various types of facilities that will be available to individuals who wish to deal in adult use marijuana. So item 2 does that to some extent, at least it utilizes the terms. They're not yet defined, but they will be. It provides for 4 additional terms, which are taken directly from the legislation. 4 additional terms: marijuana cultivator, marijuana retailer, independent testing laboratory, and marijuana product manufacturer. These are 4 terms, all of which are used within the new adult use marijuana legislation. I will define them momentarily within the bylaw, but they're all utilized here. They're all added into the table of use regulations, and I believe that consistent with what I was instructed at the last meeting, I've placed them in the appropriate districts. So we have, and I'm not addressing the overlay district yet, we'll get to that momentarily, because obviously your overlay is not one of the districts that's listed within your table of use regulations. So in terms of the underlying districts, you had indicated that marijuana cultivation, at least recreational, would be allowed in the RA district, the industrial district, and the planned industrial district. You had indicated that the industrial uses, the testing and the manufacturing, which are the last 2 items on the chart, would be allowed, again, by special permit in the expedited permitting district. And you'll notice that marijuana retailers, there's ends across the board. Doesn't mean that you're prohibiting it outright, because we're going to get to the overlay in a minute, which is where you wanted to place those. But that's what we've got listed here. You'll also notice there are a couple of footnotes, 9 and 10, only because 1 through 8 are already included within the existing table. And these are a couple of footnotes that provide some specificity, some clarity to the reader. The first is that with respect to these references to SP, there is a statement in your zoning bylaw that says that the special permit granting authority shall generally be the zoning board of appeals unless specified otherwise. So I want it to be very clear, consistent with the instruction I was given at the last meeting, that it's the planning board that'll be the special permit granting authority. So I've said that, and then I've distinguished between the SPGA for marijuana establishments, meaning recreational, and for medical marijuana treatment centers, where we're maintaining the existing framework. That is a question for you. Again, I did not modify the existing framework for medical, and as you know, the special permit granting authority for medical is the selectmen. And so I've not made a modification to that, so we do have somewhat of a dichotomy here, where we have the planning board acting as the special permit granting authority for recreational, and we have the Board of Selectmen, or the Select Board, acting as the special permit granting authority for medical, consistent with the existing scheme.
And just to remind people, because medical marijuana, the select board is the Board of Health, so health and medical seemed to go together back then, so.
Fine. And then you can see here, the second footnote is footnote 10, which is simply alluding to what I had stated before, which is that there are certain types of marijuana establishments that are authorized by special permit within the marijuana overlay district, which we'll address momentarily. So that's the entirety of item 2. Item 3 is simply the deletion of a footnote in the dimensional requirements section of the bylaw, and its replacement with a slightly different footnote. This is, to some extent, more form over substance. You have a footnote that references medical marijuana treatment centers and provides a standard for which they shall be cited, no closer than 500 feet from a public or private school, daycare center, or any facility in which children commonly congregate. I have simply, number 1, expanded that to reference both medical marijuana treatment centers and marijuana establishments. And number 2, I've also tweaked the language just a bit, because it's been clarified in the more recent legislation in terms of how you go about measuring that distance. It's measured in a straight line from the nearest point of the facility to the nearest point of the medical marijuana treatment center or marijuana establishment. So I've just mimicked the language of the statute and regulations in that regard. So that's a simple change. The real meat of the zoning amendment is in articles, or items 4 and 5 of the article. Item 4 makes changes to the existing medical marijuana overlay district section of the bylaw, and item 5 adds the new marijuana establishment section dealing with recreational use marijuana. Item 4 is complex in how it's structured. Again, often the case when we deal with modification of zoning provisions, where we're not simply striking a provision in its entirety and replacing it with something else, but we're trying to work words into an existing document. It can be confusing if you don't have the document before you. I know I have it before me. I think you have it before you. It's section 4650 on page 52 of your document, if you have the same version that I do.
Yep.
Entitled Medical Marijuana Overlay Districts. And I'll try to explain without reading verbatim these Roman numerals 1 through 6, what we're trying to do here. The first is we're renaming this section of the bylaw. Right now it's called the Medical Marijuana Overlay District, but I mentioned before that the overlay district is going to be used for both medical marijuana as well as recreational marijuana. And so I have simply entitled this section, as revised, Medical Marijuana Treatment Centers, not specifying that we're dealing only with an overlay district. We will deal with the overlay district within the text, but this is the section that will apply strictly to medical marijuana treatment centers. I've then gone about making certain modifications to sections of, or subsections of 4650 that are specific to medical marijuana overlay district, replacing that term with just the term marijuana overlay district. I have tried to be clear in the applicability section as to where these uses will be allowed. And so if you look in your amendment, specifically Roman numeral 4, you'll see that we are deleting from subsection 4654. I'm going to read that section in its entirety because it's only one sentence. The way that it currently reads, it says applicability. Medical marijuana treatment centers shall be allowed only within the medical marijuana overlay district with a special permit issued from the Board of Selectmen and according to the requirements of General Laws, Chapter 40A, Section 9, and Section 5300 of this bylaw, including application of the standard and consideration of the factors referenced in Section 5320. That's how it currently reads. So what we're doing in terms of modifying this is we are striking that first portion of Section 5654, where it speaks to medical marijuana treatment centers only being allowed within the overlay district, and we're replacing it with the following statement. Cultivation-only medical marijuana treatment centers shall be allowed within the residential, agricultural, industrial, and planned industrial zoning districts. Medical marijuana treatment centers for product manufacture and processing shall be allowed within the expedited permitting district. And all medical marijuana treatment centers shall be allowed within the marijuana overlay district. So I want to be clear about what I've done here because I think it's somewhat different than what we had discussed a couple of weeks ago. And I think it's different only in one way in particular. My notes reflect that you had said the following. We had talked about three types of adult use or recreational marijuana facilities: cultivation facilities, manufacturing facilities, and retail facilities. You had said, with respect to cultivation, okay in the RA district, okay in the industrial district, okay in the planned industrial district. And then when we moved on to manufacturing and retail, which are less the types of uses that might be appropriate in a residential zoning district, you said they could both be allowed in the overlay, retail and manufacture. And you said we should also allow manufacture in the expedited permitting district because it's more industrial in character. I think that all of that is captured in what I just said. But what is also captured in what I just said is the allowance of cultivation in those districts as well, cultivation in the overlay district. I did that because you're currently allowing cultivation for medical marijuana within the overlay district. So although that wasn't the instruction that you gave me a couple of weeks ago, and certainly this is a fluid document, this has not been published yet, this is not an official public hearing, so I only put it in because I wanted to make the point. Certainly it can be removed if that's the will of the board, but if you're allowing cultivation for medical purposes already within the overlay district, it would seem that you would also allow cultivation for recreational purposes because the cultivation is really not distinct medical versus adult use. Maybe you feel differently, but that's something you ought to consider because I've not seen other communities that have opted to zone, and they're all in a similar position to Deerfield in the sense that they're all proposing these sorts of amendments for the upcoming annual town meeting, who have not allowed or permitted cultivation of recreational marijuana in the same districts where they're already allowing cultivation of medical marijuana. They've allowed the cultivation to occur in the same locations. They've clearly been more questions concerning manufacture and retail, particularly retail of adult use versus retail of medical use, which is going to be a very different function. So that's something to consider, but that's how that's currently been drafted.
Is planned industrial a DEDIC? Is that all that's in there?
Planned industrial is the industrial park over there, yeah.
So in other words, we were told last meeting that they couldn't allow it there. Does that mean that could still possibly happen?
I'm not sure I understand the question.
Well, I guess he's the chairman, Paul.
Right, so just to answer that question, because we talked about it earlier, is that we can still zone it for that, and then they can not allow
They
it there.
can,
Oh, okay.
that's
But
not a
he was talking about
federal
federal
law.
policy and stuff, but if federal changes, it's better to just have it. So
Okay, all right, I see.
it's
All right. I was just wondering
It's
why the-
relevant, but it's
Yeah,
not,
okay, all right.
Yes.
So, a question here is that on our use table up on the first page of your document, marijuana cultivator, it's allowed with a special permit in industrial and planned industrial, which is what our medical marijuana overlay district already is.
That's correct.
So it seems it's repetitive then.
Well, no.
To add your sentence.
Well, the way that the overlay district is described, it's somewhat more extensive than simply the planned industrial district.
Yeah, and industrial.
But the only industrial, it's not all of industrial, it's only industrial over across from Red Roof Inn.
Right.
Mr.
So
Chairman.
industrial would make it probably like where
Deerfield.
Channing Beat is, Yankee Candle.
Behind Gripco Bus.
You know, anything that
That
might be in
strip
East
between-
That whole
Deerfield.
strip
Mr.
up the
Chairman?
railroad tracks.
Well, we have to go
The
look at
map of the
Yeah,
MMOD
the
is
maps are
attached
in
to
the,
the back. So you have your official zoning map. This is Pat Smith from Furlong.
Yeah.
Thank you. So you have your official
Strip up
zoning
the
map, and then
backside
also
of
the
this
map of the
residential.
MMOD follows that, so you can see exactly where.
Yeah.
So the whole section up behind North Main Street.
Right, but what I'm saying is on your first page, by having a special permit in industrial for marijuana cultivation is bigger than medical marijuana cultivation.
Okay.
So is it necessary to say, medical marijuana treatment centers shall be allowed, cultivation only, medical marijuana can be allowed in residential?
It's necessary because the terminology on page 1, under item 2, the terms marijuana cultivator, capital M, capital C,
Yeah,
refers to adult use or recreational cultivators, not medical cultivators.
oh, so medical isn't assumed under there?
Medical is not assumed under
Not
any
yet.
of those 4 terms in item 2.
Okay.
That's the thing, that's
All
the
right.
transfer over,
So that's
that
what you're
when
saying,
that
that
happens.
a year and a half from now, that might all go away, but for now, you're trying
Right.
to,
This is the challenge, that these terms, and again, somewhat disjointed in the manner in which we're reviewing this, but when we get to the next page and I define these terms, you'll see that all of these terms,
Yeah.
marijuana establishment, marijuana cultivator, marijuana product manufacturer, marijuana retailer, marijuana social consumption operation, they all refer to recreational use marijuana because they are not supplanting or replacing the existing structure, the existing regulatory scheme for medical marijuana at this time. There is a statement within the regulation that, again, effective end of the year, CCC takes control, the existing regulatory scheme is rescinded, and then it becomes the responsibility of the CCC to regulate for medical marijuana together with regulating for recreational.
But by excluding the C2, East Deerfield by the train yard is like excluded, right?
yeah, we haven't,
Right, we haven't discussed that, but that's what I'm just saying, maybe that would be appropriate area. It wouldn't impact many people, but maybe some people that live there might not want it, but
But
it's not even on the board.
Yeah, and we didn't consider it at the time, because we were
Right.
looking to minimize but at this point, you can't minimize it if it's gonna be then right in Greenfield too, I mean, it's not as useful.
But the RA district is like 90% of our town. And I don't know if that's all appropriate.
But if we do it
spots.
by special permitting, then
Right, you
we
can,
got a hand on the
right, you
gear
could
shaft.
delete it, but I almost think the C2 or the train yard is maybe should be included, but I don't know. That's my opinion just.
My memory of the medical marijuana thing that we picked was to have it all done by the industrial park and the industrial that was next to the park, because the police wanted to have close to them, they wanted to have the access to get there quickly
I agree, that was,
They
to
wanted it in
oversee
one
it. That's
area.
that's why this was picked as an overlay district.
I remember, yeah,
To monitor, yes, that's what they did say.
yeah, that was
So
our
that was the
concern.
reason that this overlay district was set up the way it was.
So confined.
Right, but it's sort of out the window now. If you use all RA, it's everywhere in town.
Right.
Yeah, yep.
So I
well,
don't
we
know
were
if that's-
talking medical, we were talking retail, not cultivation, though.
Right, that's the thing.
Well, I
We
think
were-
we're talking both,
we were talking
medical
talking-
and
Everything. Sorry, we were
Yeah.
talking both, but we were talking retail. Now we're not talking retail. That's kind of the difference.
I don't think that's true, is it?
Well, I'm sorry, we're not talking retail in RA.
Right, and I've distinguished in a manner that there was no, the existing medical marijuana overlay district bylaw doesn't distinguish between types of medical marijuana treatment centers. The term is used generally, and that term includes everything from cultivation to dispensing to product manufacture. In the new version, I have, for the purposes of assigning them to appropriate districts in a manner that is somewhat consistent with the adult use marijuana, I've now distinguished in this lower Roman numeral 4, in item 4, I've distinguished between number 1, cultivation only medical marijuana treatment centers, which are allowed in the RA, the industrial, and the planned industrial. Number 2, medical marijuana treatment centers for product manufacture and processing, which are allowed within the expedited permitting district. And then number 3, all types of medical marijuana treatment centers, which are allowed within the overlay district. So the overlay district is the only district consistent with what exists today, where all types of medical marijuana treatment centers are allowed, but you're expanding it, at least if you adopt what I'm proposing, you're expanding it to allow for the medical marijuana treatment centers that are going to cultivate only to also be allowed in the RA, the I, and the PI district, and for the manufacturing MMTCs to be allowed also in the expedited permitting district.
I don't remember any mention of the expedited permitting district in the last meeting.
Yes, there was.
I have it in my notes with respect to manufacture.
I think at the end, we did, someone mentioned.
Yeah, we talked about it, but
But
I didn't
it's
know
like-
if we ever came to any conclusion. That's how I remember it, but.
For certainly, there were no conclusions reached. I just sort of took what I
Yeah.
had and tried to create
Yeah,
a
I'm
working
not
document. But
finding fault.
this can entirely be modified. We can add districts, we can subtract districts. That's entirely left to your discretion, and I can work the language appropriately. So you can reject what I've done, you can add additional districts, or we can condense the districts where they're allowed.
I believe there's a couple of daycares on Sugarloaf Street within 500 feet.
Yeah, I remember that being mentioned.
And certainly, it couldn't be done there then, even if it were allowed in the district, because it wouldn't meet the dimensional requirement. I just want to be mindful, and this is the challenge in having both medical marijuana treatment centers allowed in one bylaw and marijuana establishments for adult or recreational use allowed in another. I want to be mindful of the fact that a cultivator ought to be able to cultivate, at least this is the sense I'm getting from those that I've spoken to, not only on the municipal side, but on the developer side, be able to cultivate for both medical and for recreational. And the reality may be, in short order here, there may be no distinction even from a regulatory standpoint. So I just wanted to try to mesh the two for purposes of zoning, but that's something that can certainly be worked through more tonight or in future public hearings. So that's what Roman numeral number 4 does. The last thing I'll say about the medical marijuana is lowercase Roman numeral number 5 makes a few tweaks to section or subsection 4655. This is just the section that identifies the special permit requirements. And again, this is more a legal modification than it is a substantive or procedural one. And that is that currently that subsection 4655A speaks to qualifying for a special permit if the MMTC has been certified by the Mass Department of Public Health. And just in an effort to not avoid us having to update this again in 8 months, I've made reference to also the Cannabis Control Commission pursuant to any future regulation, so that, you know, whatever may be applicable, whatever the appropriate scheme may be at the time, the licensing scheme may be at the time, that's the one that would apply.
Good.
So that's really the sum and substance of what we've done to the medical marijuana overlay district, converting it to what's now called a marijuana overlay district. Item 5, which begins on the bottom of page 2 of the handout, and what comprises the remainder of the handout, is a new section. I've identified it as 4660. It could be wherever you'd want it to be within the bylaw, but for numbering purposes, that's what I've done. It is entitled marijuana establishments, which is a defined term, which we'll address momentarily. And this is the self-contained section that addresses marijuana for adult or recreational use. I made somewhat of a judgment call here in how I structured this, because there's always a question when we're adding new terminology within a new proposed section of the bylaw. Do we add those definitions into the definition section at the very end of the bylaw, or do we contain them within the section that we're adopting? Rule of thumb generally is if it's 1 or 2 or 3 terms, at least this is my rule of thumb, we tend to add into the definition section. It's not too bulky. That's where most readers would look for a definition. And in fact, that's what was done when you adopted the medical marijuana overlay district. MMTCs are defined in your definition section. As you can see from this, and this is out of necessity and actually quite simpler than some other bylaws I reviewed as samples, you've got 1, 2, 3, 4, 5, 6, 7 new terms, each with somewhat lengthy definitions that are needed for purposes of this bylaw amendment. So I've opted to include them, as you've done in a few other areas of your bylaw. So it's not like I'm setting precedent here, because it's been utilized elsewhere. I've utilized these definitions or created these definitions within the new bylaw section itself. So 4661 is simply purpose. It identifies the purpose of the bylaw. I've quoted or stated, paraphrased, the purposes that are authorized by the legislation that was just adopted as revised in 2017. Section 4662 is the definition section. We've got the 7 definitions I just referenced. I'll read them and briefly describe them. Independent testing laboratory. These are the facilities that are authorized, in fact, by an entirely separate section of the Mass General laws for purposes of testing marijuana, both for recreational purposes as well as for medical purposes. The term marijuana itself is identified, again, consistent with the statute. I'm going to skip over the next one and go to the fourth, marijuana establishment. This is the all-encompassing term. And you can see that in the definition, there are several other capitalized terms, which are really all the other terms that I've gone on to define. A marijuana establishment is either a marijuana cultivator or an independent testing laboratory or a marijuana product manufacturer or a marijuana retailer or any other type of marijuana-related business that's been licensed by the Commonwealth. So marijuana establishment is the all-encompassing term for purposes of adult or recreational use marijuana. And then we've got the testing laboratories I referenced a moment ago. We've got product manufacturers, which is the next definition. We've got retailers, which is the next definition. And then we've got marijuana cultivators, which is up above. The only other term that's defined is the term marijuana social consumption operations. That's the fancy term that the legislation uses for these marijuana cafes where you can consume marijuana on the premises, either bring your own or purchase it and consume it at the premises. Those are the social consumption operations. So 4662 provides all those definitions.
Can I, independent testing laboratories, that feels new to me, so I just want to go back to that. Is that run, are those private? Is that the issue, or are those state-run? Who runs those?
They're private facilities.
That's a private facility?
Yeah, they're licensed by the state, though.
Okay.
Yep. And you can see that they're included within the definition of marijuana establishment, which is why I thought it was appropriate to include them as a category. I lumped them together with manufacturing for purposes of locating them, as we'll discuss momentarily. But I thought it was appropriate that there be a definition. Most of the other examples, and the example we talked about, the Montague model at the last meeting, which was one of several that I looked at in trying, and I think that the instruction I had gotten was to craft something that was maybe similar to that, and so I utilized that as a framework. They had provided for these same terms: marijuana retailer, cultivator, product manufacturer. They identified marijuana research facility or testing laboratory, so they use slightly different language, but the definitions are the same and they mimic what's contained within the statute.
Can I get back to that? What does they do? What is that? I just don't get it. What is a testing laboratory?
They would test for THC levels, things like that.
So it's to quality control for the
QC,
company?
I would say, yeah.
Right? Okay, just
I think
checking.
that's
It's just new to me. So, they're going to be hand in hand with the manufacturers somehow, right?
Most likely.
More likely, okay, sorry.
Adam, just curious, it's not a big deal, but when they talk about marijuana social consumption operations, how does that deal with the smoke-free employment
vapes.
rules for the state boards of health?
There's no smoking in bars.
Right. Well, these are facilities the same way that you could license a cigar shop to allow for smoking on the premises. These facilities allow for smoking on the premises. They're explicitly allowed by the law. We'll get into momentarily whether they're permitted in Deerfield and how you go about permitting or prohibiting them. There are still some questions in that regard. I know we discussed it a bit at the last meeting. I knew it may come up again tonight, so I did a little bit of additional research. So we'll talk about that momentarily when we get to what I've included, which is a prohibition within the bylaw, but we'll address that in a moment.
Because that was a direction.
So the real meat of this item in the bylaw are sections 4663 and 4664, which is where we determine where these facilities are allowed and how they're allowed. So section 4663 says that these marijuana establishments, whatever they may be, cultivators, manufacturers, et cetera, are permitted in accordance with the use regulation schedule, which again, if we go back to the first page of the zoning amendment, that's the chart that I had created assigning appropriate locations. I've specified that they're allowed by special permit issued by the planning board as you directed. I also clarified here that all marijuana establishments that are authorized by special permit shall also require site plan review in accordance with section 5400, and stated that that review is to be undertaken concurrently. You've got a provision already in your bylaw, but I wanted to make it very clear, concurrently with the special permit process. And then I think the last sentence is important, and it's something that I added in when I went back and made the modifications to the medical marijuana overlay district bylaw, that the provisions of this section 4660 don't apply to medical marijuana treatment centers, which are governed exclusively by that previous section of the bylaw. 4664 is sort of in addition to 4663. So 4663 assigns these uses to individual zoning districts. 4664 adds to the overlay district that we have now identified as a quote-unquote marijuana overlay district. So it says in addition to and not as a substitute for the allowance of certain facilities in the section up above and in the use regulation schedule, the following additional uses shall be allowed within the marijuana overlay district established pursuant to section 4652, which is what we previously discussed in the context of medical marijuana. And I've identified 4 types of facilities, which are really all of the types of facilities. But the reason that I broke them out like this is because of number 3, marijuana retailer. I wanted to include that very specific language. Number 1, that we're excluding marijuana social consumption operations. And number 2, that these retailers are allowed only until the number of marijuana retailers equals or exceeds 20% of the number of licenses within the town for the retail sale of alcoholic beverages not to be drunk on the premises pursuant to Chapter 138. That's the language directly from the statute, which specifies the minimum number that you need to permit. We've essentially made that a minimum number and a maximum number. Once that number is hit, you no longer are required to allow for, in fact, the way that I've got it structured here, there shall not be marijuana retailers. We could structure it differently. We could say that you have full discretion then to deny them. But I thought that, generally under the special permit process, you have full discretion to deny anyway if it's not appropriate for the location. So I thought what I heard at the last meeting was that you had a desire to allow these retailers until you hit the number that the state was requiring you to hit, and then at that point you didn't want to allow them any longer, and that's how this has been structured. And my understanding is that I think that's 1 retailer in the town is what I think I heard a member of your select board say at the last meeting. 1 retailer would get you to that number. 4665, which is a lengthy section, and I'll defer to you, Mr. Chairman, as to whether you want me to walk through each of the individual sections 1 through 9. But these are the performance standards. So these are although you're going to have the authority to apply your traditional special permit standards in determining whether or not the use is appropriate, even though you're going to have the ability to apply your usual site plan review standards in determining whether or not the design of the site is appropriate, these are additional substantive standards that need to be satisfied. Things like assurance that there's no marijuana product that's visible from public ways. Things like the establishment can't be operated to cause a nuisance to the community. Things like there shall be appropriate security measures in accordance with the applicable regulatory scheme. All of those sorts of things are identified here. And again, you can read them for yourself. I'm happy to walk through them. I'm happy to answer questions you have about them. I defer to the board as to whether you'd like me to address them with greater specificity.
Quick question I had was the difference between, as you just said, that we have our site plan review criteria already, and then the Cannabis Commission is going to have its regulations. So here you'd want to put things that are not in those 2, or you're sort of, some seem to be repetitive.
Right, so there are certainly a couple, and again, I did what I could to try and borrow not just from the Montague model, but from a few other bylaws that we've drafted as a firm, and then from several others that are out there proposed for upcoming town meetings, and provide for standards that I thought gave you the ability to address some of the issues that arise with greater frequency in the context of something like marijuana, without being overly repetitive with regard to the criteria. So things like nuisance, certainly you could argue that under your special permit criteria, you have the ability to deny a project because it's going to result in disruption or some other form of nuisance. But the concept of appropriate security measures, a protocol, providing it to the planning board and subsequently to the police department with a copy of an emergency management plan and contact information for a facility representative available 24 hours a day, certainly that's more stringent than what you've got under your general special permit criteria today. The concept that no marijuana-related public events shall be permitted except in accordance with the statute and only if and as may be authorized by the planning board from time to time. That's something that's unique to marijuana. So most of these are either unique to marijuana or address issues that will be raised with greater frequency in the concept of regulating marijuana establishments.
Adam, is there any conversation about the types of advertisement that a facility can do? In other words, if you take go back and look at the tobacco industry. Is there regulations prohibiting, pink elephants with white balloons selling this, or targeting young people, or, rock stars and motorcycles in their advertising? Is that type of advertising that might be deemed targeted at youth prohibited?
It is. And so there are several pages, in fact, within the recently released draft regulations. So I say they're in draft form because we don't know what the final version will look like, but presuming they're substantially the same as what has been released in draft form, there are several pages that address advertising. So much is being regulated, I mentioned before, and you heard others say, so much is regulated, as it was with medical marijuana. So much is regulated at the state level, and so there are several pages that address advertising, none of which is really or should really be an issue for the town, except when you get to questions of signage. And so there is a reference here, and it's the next section, 4666, that I've entitled signage. Now, some bylaws have opted not to address signage whatsoever. I think it's appropriate. I think it's bound to be raised. And I think it's important that it be addressed here because you're allowing for certain types of facilities in residential districts. And so, number one, there is a general concern for extensive signage in a residential district of any sort. And number two, most communities, Deerfield included, you don't really have provisions governing signage in a residential district because there is typically not signage in a residential district. So I tried to provide for some flexibility here. So what I've said is, notwithstanding anything that's in section 3200 of your bylaw, which is your signage regulations, a marijuana establishment may have one sign identifying its name and the products and services produced or available thereat, not to exceed 16 square feet in area, which I think was the smallest sign that you've allowed in any district for any non-residential district for the other types of uses. You allow some that are quite a bit larger. Which sign shall be affixed to the building or structure, because in some other instances you allow for freestanding signs, and shall not be a roof sign, which again is something that's allowed in some of your districts, but not in all of them. And then I say, except where the provisions of section 3200 are less restrictive, in which case the less restrictive provisions of the section shall control. So if you're in an industrial district and the industrial district signage regulations would allow you to have a somewhat larger sign, you're allowed the same sort of a sign that anybody that's operating another sort of facility would be allowed, which I think is a necessity. I think for First Amendment and other reasons, you couldn't restrict signage for this sort of a facility in a manner that you weren't restricting signage for another sort of industrial facility or retail facility in the same district. But certainly when it comes to allowing signage in locations where no signage would typically be allowed, I tried to impose a standard. Whether you think that's appropriate or not, that's discretionary on your part. I put a 16 square foot standard in here. You could decide you didn't want any signage in a residential district, and we could impose that sort of a restriction in here. It's entirely up to you. And then I have a statement at the end, all signage shall comply with the general sign requirements of 3230 insofar as applicable. There are restrictions concerning things like lighting and such of signage, and we want those to apply to all signage that's being proposed for any one of these sorts of facilities. Section 4667 is a section entitled transferability. I think we had touched on some of this at the last meeting, but we hadn't gotten into it in any great detail. And so I'll speak to my experience generally, not necessarily with marijuana establishments, but with other sorts of, I'll call them unique, although they're increasingly less unique, but newer uses. So I've seen this in the context of solar facilities, wind turbines, certain mixed uses, where there is a concern that the permit could be transferred. There is a review during the permitting process of the wherewithal of the applicant to be able to exercise the functions that are required to operate the permit. The ability to maintain an adequate surety, for example, in connection with the decommissioning of a solar facility or a wind turbine. And in those contexts, boards have said, we want to be sure that if there's going to be a transfer, we're notified of the transfer. It won't be unreasonably withheld, but we want an opportunity for you to come before us, seek permission for the transfer, and notify us of who the transferee is going to be, and ask them for a copy of their certificate of good standing, that they're an organized entity, and so we know who we're dealing with and we know who we're contacting in the event that there's an emergency. So I've enclosed or incorporated certain transferability provisions that say that neither any special permit nor any accompanying site plan approval shall be transferable and will immediately terminate should, number one, the recipient either cease operation of the marijuana establishment, or number two, the recipient's license from the Commonwealth either be terminated or expire, or number three, the recipient assign, convey, or otherwise transfer the permit contrary to the above requirement. Now, certainly nothing would prevent an applicant coming forward and seeking the transfer of a permit, which would essentially be the application for a new permit by the transferee. You could modify this language and make it a bit more forgiving by saying, shall not be transferred without permission of the planning board. And further, will terminate in the event that the following things happen, and that suggests that you can invite an applicant back without having to make a new application to authorize the transfer. I've had boards do it different ways. I was recently before another board representing a private applicant for a solar facility. It was a friendly facility. The board supported it, but the board said, we want any transferee to come back before us with a new application. You're not coming back before us seeking permission to transfer. We want you back for a new application, submit plans, let's do this all over again. We don't know who's going to be on the future board, what they're going to know about today's project. So that's what we'd prefer. So again, I defer to you here. We can tweak the language accordingly, but I thought it was appropriate there be some form of transferability provision in here. 4668 is a lapse provision. It's the same one or substantially the same one that you've got in the medical marijuana treatment center section of your bylaw that says that the special permit shall lapse 1 year from the grant, which is a bit shorter than the 2 years that is otherwise allowed elsewhere in your bylaw. And then 4669 is entitled Prohibition. I mentioned we get back to this, and this is one that I want to talk about for a minute or two, social consumption operations. So let me read first what I've got here, and then we'll talk about why I've phrased it the way that I have. So it says, all marijuana social consumption operations are expressly prohibited anywhere within the town of Deerfield. Provided, however, that said prohibition shall apply only insofar as the same does not conflict with Massachusetts law or has not been preempted thereby. So here's the issue with social consumption operations. There's a provision in the legislation. Don't believe that it was in the 2016 referendum legislation, but it was in the 2017 recodification of that legislation by the legislature. And when they recodified it, they essentially employed a double negative in their sentence addressing social consumption operations, suggesting that municipalities, if 10% of the voters were to seek to have a question placed on the ballot that would not allow social consumption operations, that unless a majority approved of the social consumption operations, that they would not be allowed. What does that mean exactly? So I've heard a couple of different opinions on that. To the extent that I could say that one of the opinion is more universally adopted, it's been that social consumption operations are not allowed unless there is an express allowance of them by way of a vote. I've heard the contrary opinion that no, that's not what they meant. It's a double negative. What they mean is that if you want to prohibit them, 10% of the voters have to put a question on the ballot, and then if it gets the majority vote to disallow them, meaning it didn't get a majority vote to allow them, then they're disallowed. To confuse things even further, when the regulations were adopted by the Cannabis Control Commission and issued in draft form just a few weeks ago, they include these social consumption operations as a subcategory of quote-unquote marijuana retail establishments. Well, wait a second. Up until the regulations, we were thinking that they weren't retail establishments, because we all know if they're retail establishments, the only way you can prohibit them is by way of a referendum vote, because you're a yes community. You voted yes to allow recreational marijuana. So are they a subcategory of retail establishments, or are they a category unto themselves that are deemed to be prohibited unless the populace allows them? It's not entirely clear. Again, you could talk probably to a half dozen attorneys and get a half dozen slight variations on the answer to that question. But we've taken the more conservative approach here, and we've said that they're prohibited in town. I thought that was what I heard as the preference of the board. If I'm mistaken, I apologize. But I've said that they're prohibited, but then I've gone on to try to caveat that as best as possible so that this doesn't get flagged by the AG, and the AG doesn't say in approving the bylaw, no, you can't do that, we're striking that whole section. I've included a statement that says, provided, however, that this prohibition only applies if it's not contrary to Massachusetts law. So if in the course of us adopting this and putting this out for a public hearing and voting at a town meeting, the regulations are finalized, if interpretations are issued subsequent to the regulations being finalized that state that, no, you need to get a referendum vote if you intend to prohibit these, well, then this section 4669 is not going to be enforceable. However, if that's not the case and the majority of us are right, and we think, in fact, that you can prohibit these, well, then they're prohibited because it will be consistent with Massachusetts law.
Going back, marijuana social consumption operation means blah, 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 in the definitions.
Yes.
It says that, and that's what we're talking about, right? Yep, social, right.
We are.
So it says license to purchase or otherwise acquire license marijuana. So these operations, these cafes this doesn't disclude like a social club that would be including, a social club like you'd have at, I don't know, men's club, where everybody's invited, you belong, and then you are allowed to smoke marijuana there. Does that disclude that? No, it doesn't.
So I'm not sure that it would. That club would need to be licensed. I mean, remember, each of these individual entities needs to go through the licensing process,
Right.
even a social consumption operation.
But a social consumption operation here is very specific, that it's about purchasing or otherwise acquiring from the medical, like, does that include a social club?
I think that's the intention.
Okay.
In fact, I saw on the news just a couple of weeks ago that there was a proposal for the opening of a marijuana cafe that won't sell marijuana.
Right, like that.
Right. That is simply going to
I don't know
be
how to call it.
a lounge.
Right, a lounge, right.
At which individuals could come and I'm not sure.
So that like, in other words, this definition is not created by you, this is a definition that's created
Straight from
by
the-
the CCC.
That's correct.
Yeah.
Yes, Pat. Yeah, come on up.
So this whole social consumption facility is very new, as Adam has alluded to in these regulations. Previously, people talked about marijuana cafes, and so that's kind of what you have been describing. The social consumption facility is actually is much a broader definition. It allows for a yoga studio to have a room where people can go and consume marijuana, though they are at this point in time not allowing smoking of marijuana, but other vaping or marijuana infused products or whatever. There would be they're talking about movie theaters, and so they have distinguished two types of them: primary, which would be just simply the marijuana cafe as we think about it, that's all they do, or a mixed use, which is where this would be allowed within the confines of another business. This has created a lot of confusion. I think there's a lot of pushback that I've heard after the public hearings to the Cannabis Control Commission about this specifically. And I think the governor and others have spoken to the Cannabis Control Commission and asked them to, maybe put the brakes on this and keep working on this particular type of facility as well as the delivery-only facilities that have raised a lot of questions in the communities. So we'll have to see what happens when they issue their final regulations. So I think the idea from outside is to start moving towards brick and mortar retail licensing to start, and kind of step back and think about these, because it really has broadened the definition beyond, I think, what people were thinking about before and beyond what they may be comfortable with at this point in time.
And I think the greatest challenge is that the first use of this term, this concept of a social consumption operation, is in the regulation. So these other terms, marijuana cultivator, product manufacturer, retailer, these were all terms that were used back in late or the summer of 2017 when the legislature recodified the legislation. There was a reference to on-the-premises consumption, but that's how it was referred to, the on-the-premises consumption. And then suddenly when the Cannabis Control Commission released its regulations, they had this concept of a social consumption operation that seemed to be a subcategory of retail establishments that provided for these mixed uses. And there are still very many questions. And of course, we're still working with a draft form of regulation, so we don't know.
But it's easy for us to leave that prohibition in there. That way we don't have to worry about what the commission comes out with.
If it's enforceable, right.
Because the commission might delay it, but they might not, so.
Right.
Now, at our last meeting, we talked about having different setbacks for where would that be in the bylaws?
I'm glad you addressed that, because I meant to make mention of it when I got to, I guess, on page 4, 4663 and 4664, where we address overlay district, and then we jump, the applicability in the overlay district, and then we jump to performance standards. So I haven't addressed dimensional requirements that are unique to marijuana establishments. I remember one thing that was said at the meeting, because I have it in my notes, which was, and I'll tell you what my notes say. They say cultivation/processing, no acreage requirement. And I think the reason I had that in my notes is because in the former version that I had circulated, I had a 5-acre requirement. But I said to myself, did they mean absolutely no acreage requirement? Because when you went the route of zoning for medical marijuana, you didn't modify dimensional standards. You allowed medical marijuana treatment centers in certain locations within the overlay district specifically, but you didn't address the otherwise applicable requirements of the underlying district with respect to setbacks, frontage, lot area. You didn't address those.
Well, I think as I remember from the last meeting we had, the setbacks were because it was going to be in residential agricultural, so therefore it wasn't going to be out in the middle of nowhere. It was going to be in amongst residential housing, and I think the concern was that the setbacks be different.
Right, well, we wanted to be able to regulate it so
Yeah.
that we were fair, right?
Right.
So that there was a set understanding of what was available, not just anybody in RA, but people who've met these
Right.
qualifications.
And so I guess
Restrictions.
I've got a couple of questions then for the board, and not questions I expect to have answered tonight, but that would need to be answered before we get the next version prepared, which would be ready for a public hearing. The first is a question about acreage requirements. So currently, the RA district is 60,000 square feet, is that right? So you would not be permitting these facilities on any site less than 60,000 square feet in area. So is that acceptable to you in the RA for purposes of cultivation? My guess is that most of the sites that would propose cultivation would be larger than that anyway. That's, what, an acre and a third?
Acre and a half, yeah.
So that's one question. And then when we deal with things like setbacks and frontage and other sorts of dimensional requirements, do you want to adopt a table that is specific to marijuana establishments? Or do you want to impose them only, for example, in the residential district, maybe imposing the more stringent industrial? We have to decide if we're going to impose standards across the board in all districts for these facilities, or if we're going to say, well, the industrial and planned industrial and EPD standards are okay for purposes of the types of facilities that are allowed there, but if we're going to be allowing any type of a marijuana establishment, namely cultivating, within the RA district, we want to be sure that we're imposing more stringent standards than already exist in the RA district. I can easily work that into the self-contained bylaw here, but I need some guidance as to what those substantive standards would be, because I don't want to guess at what you deem to be appropriate setbacks. You'll have some flexibility within a special permit context to say, we want you to shift this here, or a site plan approval context to say, we want you to shift this here, we want you to move this back, but you only have, as you know, site plan review, you don't really have the teeth that you have when you've got an objective standard in the bylaw that says minimum 50-foot setbacks. You can't deny a facility because they're proposing a 42-foot setback, but otherwise they're fully compliant with your standards. So if you want to impose true minimums, we need to know what they are.
And right now, we do have, it's just for rear and side yard, it's 10 feet in RA.
Yeah. Right. Just
200
make it
frontage, so that's.
500.
Yeah, but how do you differentiate setbacks for a greenhouse versus setbacks for an open grow? Because
You wouldn't, you just make,
Well, I can see the
Setback,
difference, and
yeah.
I can definitely see the difference between the open grow and the greenhouse.
That can be
is the
done.
fence
Another whole
considered the
question.
structure, and that's where the setback would
Well, I
be?
mean, you wouldn't even need to identify it as the structure. You can differentiate between indoor and outdoor cultivation, and you can state that indoor facilities shall be set back a minimum of 50 feet from any property boundary, and that outdoor cultivation shall be set back, any fence or other enclosure surrounding an outdoor cultivation facility shall be set back, no less than, I don't know if you're thinking more or less with an outdoor facility, but you could provide a separate standard for that. That wouldn't be an issue.
But talk about our site plan review, if you're letting 60,000 square feet be the minimum, which a lot of our RA district does, but it's an outside grow, does that mean they can cover the entire 60,000 square feet, where if they were going to build a home or a business, we only allow, is it 40% coverage or something like that? And that includes building and parking lot.
Yeah,
So
permeable surfaces.
if you have a section of homes and somebody owns a building lot, 60,000 square feet, can they go in and plant the entire?
Right, well, that's what.
Subject to setbacks, yes, because it would be permeable
it's
surface, the same way that they could utilize that for any other agricultural purpose, because it's agricultural, except it's not.
I get that, that's right.
Right. But setbacks would be one way of regulating that. We could impose standards with respect to coverage. We can create an entirely new dimensional chart, if you were to choose to do so, that would address these facilities and how they would be structured depending upon the district in which they're located. But as you can appreciate, we're regulating different types of uses, indoor and outdoor cultivation, retail uses, manufacturing uses. We're regulating them in an overlay district, in a residential district, in a planned industrial district, in an industrial district, in an expedited permitting district. This is one heck of a complicated chart. So we just need to sort of boil it down to, what your objective is and how we get at it most simply.
Should we also consider the aroma? I mean, that was a subject brought up at our last meeting, and here, if we only have a 20-foot setback, and once again, you have an area of land, and it's, 95% covered with these plants, does it subject the nearby residents to an odor that they don't particularly care about?
Right.
And how do you control that? I mean,
Much more difficult with an outdoor facility, of course, than an indoor facility, right? There are provisions within the regulations addressing indoor facilities, but not so much for outdoor facilities. So you've got the ability under one of your performance standards to address nuisances, and you could deem that a nuisance. But again, it's a more subjective criteria.
Sure.
Objective is much preferred.
That is listed on page 5 under number 4. Odor is listed as one of the nuisances that would be taken into consideration. And I just wanted to add, too, that in terms of if you wanted to do a dimensional table, you have an example of having done that, setting a particular special dimensional table for your solar zoning bylaw, which is on page 17935. So that's something you have done otherwise in your bylaw. So if you wanted to do that again, you have an example of that already. This would be a little bit more complicated, as Adam has pointed out. But that might be easier to do that separate one than to try to incorporate all that into the main dimensional table.
For sure.
Mm-hmm.
So any land that's developmental rights are sold, because you mentioned it's not an agricultural use, they couldn't raise it on that property?
I'm not sure I understand the question. So
If you sell your developmental rights, and so now it can only be used for agricultural purposes, could you raise marijuana on it? Because you just said that it wasn't an agricultural.
you're speaking of chapter land by
Yes,
selling developmental
yes.
rights?
Yeah, APR.
Right,
Well,
right.
yeah,
Because it's not agricultural.
I think I had looked into this because I was trying to determine exactly. So the zoning, it's not agricultural for purposes of 40A Section 3, which is the zoning exemption. There was some language that I found somewhere, and maybe you can remember where it was, but they indicated that it could still be used in Chapter 61.
So that's news to me in terms of there being actual language somewhere.
I'm
Maybe
gonna have to
there
find
very
it.
well may be.
Yeah, 'cause I-
To my knowledge, it's not been addressed.
Does
So
anybody here, just quickly, does anybody know whether 61A or APR land can be used?
61A should be allowed and APR is not.
You cannot, APR would be allowed if you did an open grow, but if you did a building on APR, it would not be allowed.
Right, because buildings aren't allowed. All right.
Yeah, but there's certain products that are open grows now, and if the land is APR'd, you can't grow it on it. Sod, I think, for instance.
On the way APR is not on the way
Okay, I didn't know, Jay, but
So this hasn't been addressed then by anyone? by
I
the
don't-
sounds of
I'm
it. If
just
sod's
posing
not
a question.
allowed, I can't really imagine.
I'm a little confused too, like about the 60,000 square foot thing for RA. Then what would happen in I and IP and different zones? I mean, are we still going to have the same restrictions there that are different than what they would have normally in that zone?
The minimum lot sizes in I and PI are 80,000 square feet, according to the dimensional table as it
Oh, okay,
exists
all
now.
right. That's what I was wondering if they were.
And the setbacks are a little bit more.
And the setbacks are
Yeah.
larger, they're 25 feet for the rear and side yard. This is all on page 17913 in section
Yeah.
2330, or 2320, I'm sorry.
Because I think that was brought up one other time. I think somebody from our agricultural committee came in and said that any RA land, there's certain crops, and I don't know if that's the only one, but I think that's what they specifically mentioned at one of our meetings one time, so I was just curious.
And we have both, we have APR land, we have 61A, we have nothing
Yeah,
too, so we're
but the
trying to.
61A is like a temporary,
Yeah,
it's not like a
Taxation.
permanent, yeah.
But I'm just saying, when we do the zoning, you have to zone for everything.
Well, only the stuff in this case would be RA, IMPI, and EPD.
But I think it would be sort of
The other
like
stuff wouldn't matter.
the planned industrial, where they're saying there's something that exempts it from being done in that certain district. So I would-
Federal regulations.
Right, so I would assume there's certain regulations that look at whether they consider it agricultural product, or however you want to phrase it.
And how does the town stand on that if we were to give zoning on the PI and then the government came in and said, no, you can't do it, then how do we deal with somebody that wants to put something in there if we have it in our bylaws?
So zoning can't override, the same way that you had concerns raised about the planned industrial district and the
That's what I'm
potential.
talking about
Yeah.
specifically.
Right. So your zoning can't override the provisions of title, something like restriction. Your zoning can't override federal law. So to the extent that there's a restriction on a property, either because there's a deed restriction on record or an APR, or because there are association documents that function as a deed restriction that govern the uses of property that are within a planned district. If they say that this land can only be used for X, Y, and Z, you may have 1,000 uses that are available through your zoning. But you may even get an applicant that comes forward and obtains a permit from your board, but they can't exercise that permit, not because you're going to enforce it against them, but because their association is going to enforce it against them, or the holder of the deed restriction.
Well, what you just said is that we can't make a bylaw to override federal law. Why can't we? Isn't that what we're doing anyways?
Yeah, that's the part I really don't
That's,
understand.
it's confusing to me. I mean, I just,
Well-
if we say, if we're going to make a bylaw and you say, well, you can't override federal law, well, that's what we're doing by permitting any of it, aren't we?
No, we're not doing it, because we're just permitting it because the state allows us to
I
permit it.
mean-
We're not
Yes, but
growing
we
it.
are doing it.
No.
We're sitting right here, right now, doing it.
We are making permits because of the state law. I get what you're pushing at, I don't, but at the same time, we're not breaking the law, we're creating a structure under which, if you want to say they're breaking a federal law, fine, but that's not what we're doing. We're just creating a structure that supports a legislation, you know,
And I
that was
get
passed in
that,
our.
I get that, but I guess what constantly throws me off is, like Adam said, we can't make a part of our bylaw that's in violation of federal law.
No,
You-
that's not what he said.
Okay.
Can you address this?
Yeah.
The zoning powers of a municipality can't function in a way so as to contradict areas of the law that are preempted. And so matters of title, what a deed restriction would require, for example, can't be overridden by zoning. That's not to say you can't adopt zoning that allows for certain uses within the planned industrial district. But if the deed restriction says that the property can't be used for that purpose, it doesn't matter what your zoning says.
Correct.
You will still exercise that authority, you will still grant that permit, maybe, if an applicant comes forward. Applicant makes an application, I would advise you to take action on that application. I would say the same thing with respect to the applicability of federal law. The enabling legislation, much like medical marijuana, the enabling legislation for recreational marijuana gives local control, very limited local control, to municipalities for purposes of determining time, place, manner in which these facilities are operated. You're adopting zoning, a framework, to provide you with a degree of oversight and local control over the time, place, and manner in which these facilities operate. If the federal government were to determine that it was going to enforce federal prohibitions on marijuana on a state level, so much for that authority that you thought you had to zone.
Game over.
Game over.
And we're all, you know. But it's not that we're not overriding it by making regulations. We're regulating.
I mean, I'll give you a very simplistic example. Municipalities often think that matters that are within the context that are preempted by the building code can be appropriate subjects for zoning legislation or for general bylaws. I've seen provisions in general bylaws that provide for 7-foot, 6-foot fence enclosures around swimming pools in residential neighborhoods. Building code only requires a 4-foot fence. You say, well, it's more restrictive than what the building code requires. Yeah, but Massachusetts has preempted the field. The building code controls fully, completely, entirely. You can't adopt a more stringent standard. The building code controls. I know a dozen towns off the top of my head that have fence height restrictions in their general bylaws. They're simply not enforceable. They're there. They may try to enforce them, but if the state gets wind of it and the state steps in, not enforceable.
So, we want to, I think our goal here tonight is to come up with, well, actually, let me just sort of preempt this a little.
Yes.
I discussed this with Pat earlier because it might be that we want another draft of this before we have a public hearing. So I asked what our timeline is, and Pat
Right,
has
so we had done a town
kind of a
meeting
new
worksheet,
timeline.
and I gave you one, John. I have more I can hand out to people. I have one I can give to you here. So, yeah, so this is a new one. So this assumes, because this is such a substantial rewrite, that this is today's the start date, not back when we started talking about the old bylaw from last year. And then it assumes that there will be revisions of a substantial nature tonight such that you would want to see them in a revised form before you would vote to put those up for a public hearing. So we've set that, assumed that then at your next regularly scheduled meeting on 3/5, that you would review the revised amendment, and at that point, hopefully, be able to go ahead and set that for a public hearing, which would happen on 3/26. It would be published in March on 3/9 and 3/16, with some extra days around the 14-day requirement for those notices, and then would have a couple days to get a final version onto the town meeting warrant, which will be finalized on 3/28. So we had a little wiggle room before. This would use pretty much that wiggle room up, but we did, I think it is workable to work in this more thoughtful manner and proceed to do the revisions in a way that allow you to see them before you vote them.
So tonight, we definitely at least want to come up with our recommendations on how to get to this next level of this zoning bylaw. So I would ask, are there any other big issues that anybody wants to put out? Because I think last time we waited till 3 hours into the meeting,
You
and then
mean things
people
that
come
we
up.
feel want to look at?
Yeah.
Like signage. I'd love to look at signage. I'd like to be more restrictive about signage. I feel like the residential agricultural, I just feel like I'm looking at 4x4, 2x6. It just feels large. It feels like a pretty imposing sign. I think that would be something I would want to consider, is reducing the sign potential. Additionally, the transferability, I think I'd want to be more restrictive about that. I'd want to look at that, the way those permits were transferred.
I like Adam's comment where it's a new application.
But he didn't, that's not,
Actually, that's
I
how you
agree.
have it. I think you have it the strictest.
Is it the strict to
Yeah,
me?
on
67.
Right.
So
He's got the
each
most-
time, they just would.
Start from scratch.
Start from scratch.
This is an outright,
okay,
it
okay.
expires in the event of a transfer.
Okay, then I'm in for that. I'm back to my signage.
So I had a question about that, Mr. Chairman, and that is, would this transferability clause not apply to medical marijuana treatment centers?
Right, I mean, again, I tried to limit my modifications to medical to swapping out terms as opposed to adding any substance to it, so I didn't rewrite the lapse provision to be identical, although it's pretty darn close. I didn't add transferability provisions.
For medical, but we don't have any.
I didn't add anything in.
I mean, we don't have any at this point, so.
But they could. So, Adam has described very well this sort of limbo that we're in between the existing medical marijuana regulations under DPH and the regulations to be promulgated in the future by the Cannabis Control Commission in regard to that. And, so that has driven some complications to the way this is drafted that, I think are justified by his argument, but it does add
Another level of
complication, and I think this is one of them. So, and why would you want to treat them differently in regard to transferability? And the way it's written now, they would be. I also had another question, if I might, Mr. Chairman, that because of all that work, it has separate tracks for the special permit granting for adult use, recreational, and medical treatment. And I have to say, as I've been doing research in this and talking to people who are in the industry and are working on proposals, their feeling is that they're not going to be distinguished going forward, that if you're doing a grow facility, it's going to be both. If you're doing manufacturing, it'll be both. If you're doing retail, they'll walk in the door, go to a separate size of the building. So if that is the case, then this going forward could result in a single facility requiring special permits from 2 boards, if they were going to do both. And I'm not sure that that is a level of complexity that we want to introduce in a review of a proposal. I'm not sure that I have a recommendation on how we could avoid that, but I think that's a very good likelihood going forward.
It's not necessarily a problem, though, it's just
Right.
it's the way it is.
It would be, a significant time burden and additional work on the part of an applicant, but maybe you're happy with that. I just wanted to point that out, that
Try
and-
solar.
and-
Well, but it's also, the town could decide, like we do with other things, the Concom and the ZBA and us work on something together, so
could
it doesn't.
have a public
I'm
hearing
not
for
sure that's
both
a-
boards.
yeah.
That is true.
I'm not sure that's a big issue. It's a good point, though, but.
I guess I'm still hazy on the setback charts. Are we going to create one, or are we not going to? That's
think
pretty
that's
important
huge.
for you to
Yeah,
know,
yeah.
right?
It is.
Very important.
Yeah.
I mean, it does sound like we did for the solar, we've got setbacks of 100 feet everywhere, basically. That's for the large and extra large.
And
So
was
we
that
could,
20 what?
page 35 in our zoning bylaws.
Oh.
So that almost, should we just copy that?
One of the unknowns is, from talking with people, it sounds like this odor might be an issue in that, you take a hot, steamy summer weekend, and, I mean, I don't know. I have no clue as to what it'd be. How do we come up with what's a good distance for an
Well,
outdoor?
And that gets back to the indoor-outdoor, because as the
Right.
peasant here, you can incorporate odor reduction measures on an indoor facility.
Right,
Much
but
easier than you can on an outdoor.
on an outdoor, I wouldn't even know, how do you go about thinking about how to regulate it or how to deal with it? Until you've got a problem, and then it's a big problem. I don't know.
But I would almost think security measures, it depends how much it has to be lit, or if it has to be lit
No, I meant
up.
about the odor.
I know, but I'm saying,
Okay.
when you're talking about setbacks,
Oh, yeah.
100 feet, if the place is lit up like daylight, that is not very far from another home. So I'm just saying, I don't know if 100 feet is really appropriate or not. That's pretty close.
Well, like we do in our special permit, lighting is not, you're not supposed to the light should not
Right, I know, it's
bother
supposed to
anybody.
be,
It's got to be
Ambient.
pointed inwards.
Right.
I don't know,
I don't know.
so that's part of the special permit. So you're leaning towards a bigger setback for outdoor, is that okay, Ron?
Well, even if it's
I wish there was somebody that could give us some information as to,
Anybody have any information about,
you know, is
is
anybody
anybody
ever?
going to do outdoor growing, is actually a question.
Well, I mean, that's something we can,
Yeah,
What do you say?
I mean, it depends on the owner, but I mean, most,
If you set it back 100 feet, that's going to eliminate your size of the lot.
I'm sorry, I didn't hear. what you-
Size of the lot.
Give about the odor. The regulation now, as far as I know, indoor growing is required to have odor control. Because the air has to change in ventilation, that they're required to have odor control, and then an outdoor grow is definitely going to smell. If anybody's ever been around marijuana when it's growing, it smells really strong. You're not gonna be able to control it. There's absolutely no way on outdoor that you're gonna control it. It is going to smell. There's no issue about it. And you can't say how far the setback is because the wind blows and the odor travels with it. It's like I can smell Yankee Candle over on South and River Road. I mean, it's not so bad, but I mean, they're all the way down to 8. You can still smell it. So, and marijuana is going to smell a lot stronger than cannabis. That is the truth.
So can you say no outdoor grow?
Does the state allow outdoor grow?
They allow it, but
You gotta have security measures, I think, if you do an outgrow.
Yeah, it has
grow.
specific security measures that are outlined
So they
for
have
outdoor
in the
cultivation.
laws, they passed outdoor
In the
grow?
regular draft
the
regulations,
177 page.
they do allow it and have separate security provision.
But, so now with a greenhouse, that's like a structure, so is that an indoor grow, or is that, okay. But then you gotta have a certain amount of security around those, because it's not really a
right.
secure structure.
The regulations are very strong on the security requirements.
Yeah, no, I know we talked about it before, but that's what I'm saying. Maybe that's gonna irritate some residents.
In the RA. We're
Yes.
talking about RA,
Yeah.
that's the thing.
So the setbacks would be to the fence then apparently around the structure,
I
is
think
that?
a fence would technically qualify as a structure, would it not?
I think it would. I mean, it's all how you're dealing with zoning here, so it's however you craft it. When we're dealing with setbacks, lot area requirements, these are not things that are addressed in the regulations because they're the subject of local zoning. So you could measure the setback however you want. Yes, arguably, the fence is a structure. I'd have to look back at your exact definition of
It's
structure to see whether it's
fixed in the
included, because,
ground, you know.
yeah, every town's different on what they qualify as a structure, but whether it's a structure or not, we would specify, I would draft the provision such to say, in the event of an outdoor growing facility, setback shall be measured from the nearest structure, fence, or other, other improvement on the premises.
Adam, do you know in the state regs, is there a height requirement for fences, whether it be outdoor or indoor?
I don't recall. I can find out, but I don't recall whether there's a height requirement for the fence. It needs to be fully enclosed, but I'm not sure if there's a requirement, minimum height.
The definition of structure is that it shall mean anything constructed or erected, the use of which requires fixed location on the ground, including swimming pools, satellite dishes, tennis courts, and animal enclosures. So again, I think arguably you could include fencing in that.
So
But if with an outdoor grow, I'm sorry, John, with an outdoor grow, they're saying that whichever way the wind blows, so 200 feet, 500 feet wouldn't be enough technically. So what do you do? What do you do?
Hasn't been addressed. And I'm not sure that many municipalities know yet, because these facilities haven't been permitted yet
But we could prohibit outdoor growing.
with a referendum vote.
Because we
Oh, really?
voted yes.
You can't allow indoor growing but not outdoor?
You can't just legislate it into nothingness.
Yep.
So you're going to eliminate any type of business that smells? What about dairy farmers? What about Yankee Candle? What about the pickle factory that used to be in town? We can start regulating smells. Methane digesters. How can you regulate smell of a crop? Tobacco.
And we always have regulated in such that if it's a nuisance to the town,
Didn't they do that with
if
pig
it's a special
farmers at
permit,
one
that's
point?
quite a wide, you can go a lot of places with
Businesses
that.
are already here.
You think Oxford could get a permit now? Or?
So if we were to try to outlaw outdoor, it would require a referendum. Is that what
I believe so. I'll review the regulations
Okay.
again, but
That's
the
all right. I just
regulation.
wanted to put that down here.
Yeah, it's the regulations that distinguish between the indoor and the outdoor.
Yep.
And the underlying legislation is very clear that if any type of marijuana facility is sought to be prohibited, that it requires a vote, which is why I'm cautious even about something like a newly defined term in the regulations for social consumption. Is that a type in and of itself? Does it therefore require a referendum vote? So I guess you could try and make an argument, and this is why I say I'll read the regulations again, that the type of facility that was defined in the legislation was a marijuana cultivator. And the regulations have gone so far as to divide those into indoor and outdoor cultivators. Can you prohibit one so long as you allow the other? My guess is that that would be inconsistent with the intention of the regulation and the requirement of that strict referendum vote to prohibit any type of establishment. But I'll review to see whether there's anything there. It may be that I can't give you a definitive answer because nobody knows yet.
But you could have different dimensional requirements.
Oh, for sure.
So
That
that's,
gets to time, place, and manner, then.
right, so we could say 100 feet for indoor and then more for outdoor, which you're right, it doesn't totally stop it, but as people mentioned, things smell.
Yeah, well, I mean, the other things have been around for a long time, and the other things aren't federally illegal either.
You could also choose to allow indoor facilities in some locations and outdoor facilities in others. So just because you're opting at present to allow marijuana cultivators in the RA district, you could limit that to indoor marijuana cultivation, but then allow outdoor cultivation in other districts, if the concern is about the smell in a residential
I
district.
know, but in reality, it's almost the opposite. It's-
I
Industrial's got to have the indoor and the.
I get it.
In RAs.
So, do we have any suggestions from folks here about 500-foot setback? Yep, Nick?
Remember that any licensed marijuana operation is going to be subject to the special permit. And so in the exercise of your authority, when you grant special permit, you will be able to impose all kinds of restraints and conditions and restrictions on the operation. You can address such things as others. That doesn't need to be written in the bylaws. You've got your rights under special permit. And site plan approval as well. But as to the subject of setback, my immediate concern is that you may be, by imposing a new setback requirement for cultivation operations, you may be causing some real problems for existing operations that may want to convert to marijuana. And I'm thinking of Pioneer Gardens in particular. Some of their buildings are close to the property line, and by imposing a new setback requirement to really stymie their attempts to convert. And I would encourage you to take either not to impose any setback requirements or to allow existing cultivation operations to convert to marijuana cultivation operations.
So let's come back to that, but I also had another question about size of the facilities. So in the regulation, the draft regulations, they have 4 tiers
Of cultivators.
of cultivators. And they are, I just had it here. Under 5,000, under 10,000, and then above 10,000, I think.
10,000
Square feet.
Square feet.
Of canopy.
Of canopy.
Yeah. So up to 1,000 square feet, that's pretty, and then 1,000 to 5,000, 5,000 to 10,000, and 10,000 and over square feet of canopy. So,
Now, but the canopy to me sounds like it could be not in a greenhouse, but like shade tobacco or something like that. Is that what that means?
It's not defined in the regulations.
I mean, when you say canopy,
I presume
it's-
that it means where the plants literally are.
yeah.
So it would be contained within a larger building.
Are farmers, is that right? It's plants?
Canopy, I would interpret it as actually foliage and the amount of plants. I
Yeah.
don't think it defines structure necessarily.
No, but that's what I said, that's where the plants are, that they would be then located within a larger structure. So that does not
So-
define the size of
So
the structure
canopy might be thought of as
specifically.
footprint for the
Of the plants.
growth.
The plants, yeah.
Of the plants.
Okay, gotcha.
So before I get into this, Adam, do you think could you prohibit any of those tiers?
I can't give you a definitive answer because there's no guidance so far. My sense would be no. I think the tiers are created for licensing purposes. I don't think the tiers are created for purposes of zoning or local control. I'd have to look back again at the exact language that affords the local control, but I don't think that it's so specific as to say that you can eliminate certain categories or subcategories of a particular use.
Because they refer to other things in here as micro-business and craft cultivators and cooperatives, and I just felt like that was where the sense of sort of Deerfield was going, was we didn't want really huge outfits here, but to have current cultivators to be able to cultivate, and I don't know what size that might
So craft cultivators, I think maybe something, it's a good point that you brought that up, that because I think that is, and by my reading of the regulations, that looks like the most reasonable way for local farmers to come together to do this. And I think that's why it was added into the regulations, was in response to concerns about the ability of local agriculture to be involved and not be just a total industrial thing. So I don't know if that's something that maybe we would want to call out here again as a specific type of use. At least to define it so people know what it is. I don't know how exactly we might.
Well, I guess I'd be okay with that if we were going to be regulating it differently than cultivators. If we were going to be allowing it in districts where cultivation, say, wasn't permitted. Otherwise, what's the purpose of providing?
Well, the suggestion is to do just that, is to allow some smaller cultivation in places that we might not want to have a huge one.
Right. So that'd be fine if we were going to distinguish. So there's certainly a difference between outright prohibiting a use and assigning it to particular locales. So you could determine that, okay, we can't outright prohibit cultivation, and even if I tell you that means any type of cultivation can't be prohibited, you can't allow one type but disallow another, fine. We're going to allow wholesale cultivation, any type, but we're only going to allow it in the industrial district, and we're going to allow this micro cultivation in the RA district and the PI district. That would certainly be an option. You can divide it up in that fashion. And for that reason, if that were the approach that the board sought, then we could structure a bylaw in such a way that we would simply modify the table of use regulations. We would, looking at the first page of my zoning amendment where we've got marijuana cultivator, SP in the RA, I, and PI districts, we would say, marijuana cultivator, and we provide some greater specifics there as to the larger cultivators, and then we'd say, craft cultivation, and we provide for the districts in which the craft cultivation was allowed, maybe where marijuana cultivators weren't. So we could get that specific, sure.
And again, this can maybe it's part of the special permit, because in the special permit, we look at does the proposed use outweigh its detrimental impacts on the town and the neighborhood in view of the particular characteristics of the site? So we could also at that point say, no, you can't get a special permit, it's too big for that characteristics of that site. But another comment?
I think it would be helpful if we, just to go back to basics for a minute, think about, remember, the reason we have zoning is to control the way people use land. We talk about the uses of land, not the entities whereby people employ to use land. And so when you're talking about a craft co-op or a micro business, they're still only doing one of three things. There's only three ways you can use land in relation to marijuana. You grow it, you manufacture stuff, make stuff with it, or you sell it. Those are the three uses of land. And so you don't really need to focus, in my view, on the type of entity that is operating these various uses or performing these various uses. Just focus on the uses, growing it, making stuff from it, or selling it. And decide where you want those uses to occur in the town. I think that would simplify this.
Well, I appreciate that comment. I attended when the Cannabis Commission was up there at the FERCOG 2 weeks ago, and there was a lot of discussion about the craft and the cooperatives, that was something that seemed much more welcome than big industries coming in and plopping down huge warehouses. And so that's partly the Cannabis Control Commission who's going to take that up. But it's also something zoning can take up by looking at size, not necessarily entity, but size. And size sometimes can influence entities, maybe. But my question is, here in Deerfield, what are our farmers like? What's a good size? 1,000 is too small. But 10,000, is that too big, or?
It says 10,000 and up for a reason.
So you think most of them are going to be, most people want to do 10,000 or up?
That's what I would say. And if you're gonna do craft, then you're tier 1. Why complicate it? You got 4 tiers.
So let me ask, if I can, this is maybe off topic, but if we zone so that RA can have all sizes, then what stops some, I'm going to get to some large entity, lots of money, to come in here and build a huge warehouse in the middle of some farmland in Deerfield?
Absolutely nothing.
Well, it's a special permit.
Well,
It's
I'm sorry,
discretionary.
I'm asking the audience first. I'm hoping someone could help me.
Well, so what if someone wanted to build a big widget factory in Deerfield, what would be responsibility?
Excuse me, what was that?
Widgets aren't allowed. in
Well, they're not,
widget
this is
That's
largely
the
based on RA. We're going, RA is a whole new place that we don't have big
We don't have
warehouses. We
widgets.
don't have big metal frame buildings. And so this would,
Back into, okay, farmers have done different things. My neighbor has 400 cows. Now, a generation ago, 400 cows was a lot of cows. We might have said, well, we want to might grow the small farmer, but reality is for him to make a living, he has 400 cows. So this is the same with this crop. We don't know between now and 10 years from now where that industry goes. My grandfather had a couple of acres of tulips and could feed bunch of families, but now we need 100 acres. We don't know in 30 years from now where this goes. I don't know. So to restrict that, basically take you out of the marketplace. I mean, when we started farming in 1992 here, we had 1 acre. So we could make a living with that. Now we need 4 acres. So the trend in the industry already is that you need about an acre or more to be basically a viable business, because you have to put all those security things in place. You have to do all the research and all those, So a small craft has to be a co-op, and therefore becomes bigger anyway. Because small, you can't afford to, because it's a very, security has been raised a bunch of times. You can't do that with a small pot. You can't have, 10,000 in cash and so I'm going to put a fence up. It doesn't work like that. And it shouldn't. I mean, it has to be secure. So if we can limit ourselves to $5,000 or whatever we decide, I think Jay is completely right. It has to be $10,000 because that's reality already now in the marketplace, and it's probably only going to get bigger. Can I just make a comment that I think people are missing the point that marijuana is not cows and marijuana is not corn. And so to try to treat it as such just because it's a farm agricultural product is a bit missing the point of the regulations in the way that they state. And what the state's doing with the regulations, who knows? I mean, they change them all the time. You're right. They might say today 10,000 square feet. They might say tomorrow 100,000 square feet. They might say you're going to do 100 acres. But if Deerfield and Wheaton and Hatfield alone decided to let all the land grow to marijuana, what would that mean for the crop, for the business, for the state? I mean, is anybody, I think that at this point, the only consideration here is that the zoning can at least put in some kind of control over what's going to happen, because we certainly aren't going to have everybody change to be growing marijuana instead of corn. And it is not a cow. So to say marijuana smells like a cow, marijuana doesn't smell like a cow. The cows have been here forever, and marijuana isn't even here yet. So at least just keep it in the context. Marijuana is a drug and it's a controlled substance. So it's not. Well, then we shouldn't be growing barley here. Gimmick here. And
that's
lame.
That's
Do that with marijuana as well. If the farmers are going to grow it and then send it to manufacturers, that's true. That's true. If that's the sole purpose of growing, that you're going to grow it and then send it to manufacturers like alcohol, then that would be the regulations. But as I said, the state, they change the regulations more than they voted on the legalization or not. They keep changing regulations. Now we have a new board, and so like you're saying, who knows what tomorrow? It might be a totally different thing. And outdoor growing, you see what in California and in Washington State is there's a glut, and now there's too much, and now the price is dropping, and so maybe they'll change it again out there. I don't know. Is that what they're following, the state? Does anybody know if they're following California or Washington, or are they making up their own rules?
They say they're looking at all kinds of experiences, so we'll see.
Yeah.
But I thought they said they had the rules already for the outdoor growth. Did they follow any other state? Or
I don't see, is there stuff in here about outdoor?
Yeah, it's under the security provisions. They distinguish between the different types of facilities. Sorry, I don't have mine open in front of me. But, so they do address them in the draft regulations, but they are just draft, and I'm not sure which specific.
They didn't say anything.
I don't think there's references as to which specific states they took the regulations from.
The other thing that I was curious about, I was reading that in Arizona, California, and Washington, when these plants consume a lot of water, and they have to be watered with drinkable, potable water. Is that the same here?
Very heavy users of water.
So you can't pump, you couldn't pump water out of...
wastewater issues as well, then, obviously.
But you can't take water out of the river to irrigate these things.
Can't take it out of the river without a permit already.
No, but he's
A lot of farmers do pump water out of the river to irrigate
He's
crops.
saying the water wouldn't
But
be
is
suitable.
the water drinkable out of the river, though? That's what I think they're saying, is
That's what I was wondering.
potable water.
So,
I've never heard anywhere it said that marijuana cultivation can only occur with municipal, clean, sanitized water.
Oh, okay.
Water can't be water, river water, or rainwater.
you're saying it can be watered with river water? Or,
I know, I've never heard otherwise.
really? Well, that's, in the state of Arizona, there was a big issue because they don't have enough water to irrigate some of this one particular outfit I was reading about, and that the people in that particular community were upset because they wanted to change the water pipe system to feed this facility because it used so much water. But all the taxpayers, in a sense, were assessed a fee to increase the water mains and stuff like that.
Well, the water in Arizona, also annual rainfall is only about 3 inches.
Yeah.
You get 38.
Inch, yep.
So
I was just wondering if...
comparing apples to apples.
No, I guess my question was more, does it have to be potable water, or can it be,
What does the
pump
water
water?
have to do with passing our issue here?
Yeah.
It is something that could be looked at in the context of your site, your special permit review. If, typically you might look at that. It's also a very heavy user of electricity. So it's something that could be looked at. Now, we're talking about the RA district for a lot of this, so you're going to be outside of municipal water districts, and you're going to be looking at having to go, put in system, private wells. So that'd all be something that would have to go through the normal permitting process for that as well.
I guess from my point, what all of these things have to do with is I don't want to be part of a board that down the road there's a problem, and say, well, why didn't you address that? Oh, geez, I didn't think of that. And it's just questions and learning. Everything here is really kind of unknown and green, and you get this moving target. So
I think that's a lot of why it's a special permit, because
Yeah.
that's when you can address it, is the actual time it comes in front of us.
Yeah.
So,
And-
yep, one more.
Just, reference to the outdoor growth, it's so unlikely that it will happen. Marijuana is basically an 120-day crop, so, 4 months. Our growing season here, you basically have one crop at best, outdoor. And investment, again, in the security and all those things are not warranting for an outdoor crop. It's really a non-issue, just to put that out there.
And you got impervious surface.
All right, so,
Greenhouses.
so we've learned a lot, I think, but, so how are we doing with that draft bylaw here?
I don't personally see much wrong with the draft. I just think that the other stuff that we need to address, that we haven't addressed is, as I say, is still the setbacks, if we're going to have any, and impervious surface, if it's going to be indoor. Those are the only two things that would come up in the stormwater review.
And both of those go to the dimension issue, right?
Yep, so if we
You could
just get the
address it.
dimensions and stuff set up, then I think, you know, that's... And unfortunately, I know that Whately and Hatfield, just down the road here, put in town water systems and ended up sucking each other's aquifer dry. So gotta be careful. If water's an issue, then you've got that to think about. I mean, I don't know. I don't know if it is or not.
Ask Roger, he's the water guy.
I don't think they're sucking each other's aquifers dry.
Well, no,
They
they-
maybe suck from, they pump out of the same
Same
aquifer.
aquifer, yeah.
But they're not doing that to each other. And I think Yop will address that. And Mark touched on it, it's economics. The marketplace is gonna dictate how much stuff is gonna get grown. Because if you can't sell it, and I brought this up, supposedly there's no place in Massachusetts that buys marijuana and processes it right now. So I said, most farmers want to sell their crop, or anybody that makes anything. So that's going to control how much gets grown.
Yeah, and about the water use, you know, like what we already do in our greenhouse, and they recycle the water. You know, there's basically zero water.
Mhm.
It's the most economical thing to do anyway. So we have done it, most greenhouse growers commercially already do it, and so we go around growers.
Just to collect off the roof, so, almost the entire roof, rainwater that's collected into the pot tanks, and that's used for irrigation.
Yeah, I've seen that down at Norris. They do the same thing.
But you say you recycle it, how do you recycle it?
They save it, they collect it.
Very cool.
I want to talk to the guy that does it.
Basically, what, you know, you collect that goes through a rough filter, takes the rough stuff out, and then it goes to 40
So you
mic-
repump it again, like?
Yeah, like a 40 micron filter, and then we reuse it. You know,
So whatever doesn't get
like that.
evaporated or the plant doesn't use, you collect it again and
Yeah, you
use
make
it.
sure that these seeds, the pH is whatever, all this is fine, and you just supplement them however you do it.
Interesting.
So we have the dimension tables already for
So,
all these districts, and then we have the solar one. Like I say, RA is, frontage is 200, rear and side are 10 feet. So,
John, my take on that is there shouldn't be any dimensional requirements whatsoever. It should be all done with setbacks, period.
The setbacks.
well, that's
are
what I'm
within
saying.
the
That's what I'm
dimensional
saying.
requirements.
So you do want the setbacks. So what, instead of 10 feet, how many?
The RA district, and I don't want to exclude farmers from this, but it's such a, encompass our whole community like. So it's like contradictory to what we did with the medical marijuana, keeping it isolated. And I want to give the farmers a chance because there's probably maybe appropriate places in it. But, so how do you do that and not make it even more complicated?
So if I could, Mr. Chairman, so I mentioned before that, and I truly believe that there's no substitute in zoning for objective standards. But at some point, you max out the objective standards and you start to sacrifice flexibility from project to project. And on the whole, in zoning your community for a particular use, I've heard some concerns about, well, who's to say that suddenly the entire town of Deerfield isn't comprised of marijuana facilities? Well, you're to say that they're not going to be comprised of marijuana facilities because this is a special permit use in every district where you're allowing it. So the same way that you wouldn't allow 10 grocery stores in your community because, number one, there may not be a demand for them, but number two, number three, number four, once you get that many grocery stores, you begin to run into traffic problems, you begin to run into problems with respect to effect on neighborhood character, all the various criteria that you apply under your special permit standards. And so at some point, the use is going to get maxed out if that were ever to occur. And the same goes for individual projects. If a project is proposed by one of these mass growers and the project is just so incredibly large in a residential district, you can determine that it's not appropriate for that district. It's inconsistent with the character of that district. That's one of your criteria. So you have the ability on a case-by-case basis. Again, I'm not suggesting you don't adopt dimensional standards. I think that having certain objective standards, if they can be applied, is appropriate. But you do have to balance that with what you've heard, for example, one applicant's representative say tonight, which is that if you've got an existing operation that may already be in violation of what will now be an imposed setback, you're going to affect that particular operation, at least with respect to that component of its project that happens to be located within the setback. There's no grandfathering here because there's no marijuana uses that are currently in existence.
I thought we touched base on that a little bit because we were concerned about agricultural facilities already if they were closer to the setbacks and stuff, and by the right to grow or something, that they'd be excluded, that they could use those facilities for it.
I'm not sure that they qualify any longer now that the legislature has clarified that the use is not agricultural. If the use was zoning exempt, then they'd be entitled to those protections. But you've got what has been a zoning exempt use that is now being converted to something that is clearly, explicitly now no longer zoning exempt. That's the challenge.
Right. So realistically, in my mind, you can't consider this farming. Although it's growing stuff, it's not farming. And they shouldn't get the exemptions that they always have. That's my opinion.
Well, no, that's what this regulation says.
Yeah.
That's fine.
Right.
It almost seems to me, just looking at this, is that you need the larger setbacks for the open growing, and you don't need as large a setback for inside growing. And when you're doing inside growing, you're going to end up with impermeable surfaces, whereas when the outside, you don't have that. So there's two things that work just in the opposite of each other there, in my opinion, that, you know, is all you need to address. But
I guess I'll just put this out there, that for the, since we doubt we're going to see any outdoor growing, if we did, then we say, well, what are you going to do to keep the odor from being a nuisance to the neighborhood? And then we can just say, you got to be 500 feet away or something.
okay.
It depends on where in town it is. If it's,
Yeah. No, the odor thing, if it's indoors, is controlled by
Right.
the air circulation.
Right.
Outdoors,
Right.
that's when you get your setback,
Right.
and that's all it's for. So.
Right.
I think some of the local farmers already suggested you're not gonna see
Right.
outdoor grow because it's just not economically
Right.
feasible. And, you know, maybe some people are gonna say greenhouses are, yes, they're in a structure, but is that really a structure, you know what I'm saying? But yes, according to Pat, it is a structure.
And they are impermeable surfaces too.
Yeah, you're right.
So if you go to the setbacks with greenhouses, then we're gonna have a problem with stormwater and stuff. And I mean, I understand you guys are gonna recycle it, and that's great. That's a
But
good thing
you're
to
talking
do.
about rainwater and stuff, that's
Well,
gonna.
RA right now is 30%, maximum lot coverage by impervious is 30%. So that's, unless we change that, that's pretty good. 70% is,
Well, that's what I'm saying.
Yeah,
I didn't
so
know.
we leave
But
that.
you see, what I think Adam was talking about is that we were gonna set up a whole nother table rather than using the existing one. So if you're doing that, then you have to establish 30%, or you have to establish
Right.
that and tell Adam, this is what we're gonna require.
but I'm saying we
That's all.
only need a new table if we want to change any of the current ones. And so that one, you don't really need to change probably.
And only if there are going to be substantial changes. I mean, if you were to tell me, we're going to keep everything as is except for cultivation use in the residential and the RA district, we want the
Outdoor, yeah.
setbacks to be 50 feet in every direction, I'm not going to craft a whole new table. I'm going to
Just
add
put a
one
foot-
sentence that says,
yeah.
no, you know, those
Okay.
dimensional standards apply,
So-
provided,
so-
however, that in the RA, you're going to have 50
So on
foot
page
setbacks.
14, we have the impermeable surfaces stuff.
So industrial and planned industrial, it's 60 and 70%. That's the nature of industrial.
Yep.
And then, but RA, it's 30.
Yeah?
Maximum building height is 35, although we didn't change that, did we?
No,
We've got it.
that didn't get voted.
So, you know, so some of that, so the only things that we might think about is this rear and side yard. But again, if it's not, if odor's not the issue, then do we even care about that? Or do we just do it through the special permit to make sure it's not a nuisance?
Well, I think that we should go to at least 25 or 30 feet because we did that in the EPD district, because it's not residential. You know what I mean? In the EPD district, it's 25 feet setback everywhere.
Oh, it's a special table.
Yep. So I mean, it should be a minimum of 25 feet anyways.
Which is what it is in planned industrial and planned industrial
Yep,
already.
there you go. But we're kind of referring to RA now is what you were
Right,
talking
right.
about, so that's why I mentioned that it should be,
So that could just be footnotes then. Does that sound good?
Sounds pretty straightforward.
Well, we got, what, no, okay, yep.
And then leave the impervious surface the same.
Then leave the same as what
30%
they are.
RA,
Yeah,
60 and 70 over there.
it doesn't matter what it's used for, the stormwater's, the effect is still the same regardless of what you're.
So my other question was, on your chart there, it looks like marijuana retailer says no across the board.
That's correct.
Then you have to go to the overlay, then you have to go to footnote 10. Certain type of establishments are authorized by special permit in the marijuana overlay district.
That's right. And that
Why
footnote
wouldn't you
10
put a SP? Did I already talk about it?
No, you didn't.
Because there's no column for the overlay, there's no column for any overlay district, which is typical of zoning. You don't include the overlay districts in your underlying table of principal use regulations.
I was going to suggest just to add some additional clarity for the user of the bylaw, that footnote 10 mentioned the fact that retailers are allowed in the overlay district.
Okay, well, so
Is that
we're,
possible?
well, I could, but
Just so that, because
but-
you are going to look at this and go, oh, no, that's not allowed. And then they're going to read 10, then they're still going to not know that it's allowed.
And I guess, the general rule, of course, in crafting a bylaw is you don't include or exclude one to the exclusion of others,
Right.
because, so if I'm going to make reference in the footnote 10 to the fact that retailers are allowed, to clarify that that's why you've got ends across the board, I also need to make reference to the fact that footnote 10 also references independent testing laboratories and marijuana product manufacturers, which are also allowed in the overlay. So that's fine, it just makes for a lengthier, I could say as footnote 10, rather than certain types of marijuana establishments, I can say marijuana retailers, marijuana product manufacturers, and independent testing laboratories are authorized by special permit in the overlay. That's fine.
And I have sort of like a basic question, like, why are we excluding it from some of our commercial areas? What's the
Actually, I'm glad you brought that up, because if we're going to do it commercial areas, we might as well include C2. The last time we were there, I
for
mean,
grow and retail, but I'm saying like our downtown area, how come, what's the advantage or disadvantage of not allowing them to have a store to
Downtown.
sell it?
Well, downtown is CBRD.
Well, I know, but that's what I'm saying, but
We didn't want it, but
Yeah, I think,
we didn't want retail. We wanted one retail. You can limit it, my understanding is you can limit it as a percentage of your liquor licenses.
right.
So we wanted to have one retail in the town of Deerfield, and it would be in the overlay district where we had medical marijuana dispensary already allowed. And that would be, because the understanding is that medical marijuana dispensary is probably going to morph into a retail anyway. I mean,
Right.
it becomes down the road it's not going to be different anymore. So the thought was, we didn't, I mean, it's up to the town, but my assumption is that we didn't want it down there.
Now, I had a question that came up too, similar to that point, that when you have the yoga studio that might have a room for recreational use. Consumption, is that a second license? Or is that not licensed at all? That's just
It's a
totally...
second, it's a license that you would have to get, and it would be prohibited under this particular.
Okay, all right. Yeah. Well, I just wondered if it was a separate license or
In the
not.
overlay district, we put a lot of thought into what, to make sure that there was no negative, or the least amount of negative impact to the community. And that was why we came up with the overlay district the way it was. And, we didn't want these social consumption things happening because, people get in their car and drive away.
Well, I wasn't saying that we should have more. I'm just saying that if we can only have one license in town, then there can't be licenses in these other places, so.
And to your question, I'm not sure that we can state as definitively, yes, it would need the same sort of license. This goes to the question of prohibition of social consumption operations. In the new regulations, in draft form, they are included as a subcategory of retail establishments. if they're a subcategory of a marijuana retailer and you're only required to permit one retailer in Deerfield based
Right.
upon the number of liquor licenses, once you permit one true retail establishment, you're good to go.
That's it.
However, that would also maybe mean that we can't straight out prohibit social consumption if it's a subcategory of a retail establishment. So do you want that, or do you want it to be such that they are not a subcategory, they're a category unto themselves, which would mean that you can outright prohibit them, but that if you didn't outright prohibit them, they'd be allowed in unlimited number because they're not a type of retail establishment? We simply don't know the answer because the
Yeah.
regulations aren't finalized.
Well, I think that was what I put it down here as a note, that you were going to check into the fact of whether, does it require a referendum vote to prohibit it?
Well, the question was, does it require a referendum vote to prohibit certain types? There was a question about indoor versus outdoor
Yep,
cultivation,
right.
whether you could prohibit one entirely,
Right.
whether you require, that's different than the question of social consumption. I'm not going to get an answer to researching the question of whether it requires
I
a
see,
referendum
okay.
vote, because there's no answer yet.
Okay, all right, thank you.
But I do, now when we start talking about the retailer, the laboratory, the manufacturer, in the overlay district, it's a very small district. It's like just a couple properties.
And the overlay district, I thought, really was driven by containment. They wanted to have it in just a small,
Right.
Well, this is
and
PI,
obviously that's out the window
No,
now
this is PI, and this is
for
I.
cultivation.
This is the overlay district.
Just for
But
cultivation.
we
The
have
red
a lot
line
more,
defines the overlay district.
we have a lot more industrial that we didn't put in the overlay district.
Oh, I see, okay, all right, well, that was my question earlier, yeah. So that's trapped behind residential property on North Main Street.
Some of it is and some of it
railroad
isn't.
tracks. Yeah, some of it isn't, right.
It's right off
Right,
of
yeah.
5 and 10.
And I think some of it probably isn't appropriate and some is,
Well,
but.
John was just saying, that whole stretch isn't in the overlay, so it doesn't matter.
I mean, the only
No, I
place.
know
in
it
the-
isn't.
The only place in the overlay is across from Yankee
Right,
Candle.
right,
It's that
yes,
small
right.
strip, which is
Right.
like,
Well, isn't,
that's almost too narrow. Well,
Isn't
you're saying
this-
now planned industrial probably isn't viable because.
Oh, I see what you're-
Edie-
I see what you're
Edie
saying.
said that's really not even a viable thing. for
Yeah,
the-
okay.
At least for the
all
foreseeable
right,
future.
yeah, I see what you're saying now.
So basically, we're saying this tiny little place where you can do any of those things. I'm just,
Yeah, you're right. That's why I mentioned, why don't you want to see it downtown?
I mean,
But-
yeah.
yeah.
At this point, what does it
And,
matter?
and it's only gonna be one, so it's like, it's
Right.
still gonna be contained wherever it is.
Just looking at the map, it occurred to me that, maybe the EPD would be a place you might consider allowing a retailer, because it's close to downtown and yet outside of it.
It's not really
Not
outside.
as far away as
It's
the
right
industrial
square in the
Yeah,
parks.
middle of
that's in the
town.
middle of the neighborhood. That's-
Right, it's right in the middle of town.
But that's what the people wanted, that's what they voted on, that's what I keep hearing, the will of the people.
Oh, I didn't hear, the EPD, I didn't hear it brought up before, but I may have just missed it, I don't know. You mentioned that the EPD had been brought up as,
Yeah, we had talked about it at the last
Okay.
meeting.
For purposes of manufacture and
And
testing,
testing, yeah.
which is
Okay.
where it's currently allowed in the draft that I've circulated, but the retailers are not allowed in the EPD.
oh, okay, yeah, all right, I see that, thank you.
So the question, I think, is do we want to let all industrial be for laboratory and manufacturing?
This is such a nebulous area that we tried to convert it all to either either to CBRD, RA, or something other than industrial, because it's just orphaned out there behind, the frontage is all on non-industrial property, except for, as Roger was saying, where Hardig or Pelican, and then that one lady that changed hers, got her residential changed to.
Pervere.
What's that, Pervere, yeah, Janice Pervere.
But I'm talking about all this is off of 5 and 10,
500 feet from the high school.
right? This is all.
I don't think that's off 5 and 10.
That's 5 and 10,
Yes,
right?
it is 5 and 10,
So
Paul.
all this is off of 5 and 10.
Where is that at? Where is that?
It's from the fire station north,
Yeah. Up to all the, where the shops are, this.
right, maybe to the vet clinic, I think, or Channing B. That's,
Okay, all right. Yeah, that's too, no. Well, where is the stuff that's behind, say, Gripco's bus?
Yeah, that's
it's
here.
off of North Main
That's the
Street.
one that sticks out over here. But most of this is off of 5 and 10.
Oh, I don't remember it that way,
That's-
but that's okay. If you say that's true, it's true.
And then C2 goes all the way, continues up a little further.
See, this is North Main Street here, right?
Yeah, yeah.
And the railroad
Everybody a
tracks.
shot at it.
See, the railroad tracks back up this here, And what does not come out to here is landlocked between the railroad and 5 and 10. So that stretch is, I wouldn't want to see that stretch be in the mix just because they got residential all in front of it. But anyway.
All right, so we leave the current overlay district the same as the medical was?
So the only issue is that the retail has to be in that one little small section there. That's all that's affecting, right? Doesn't affect cultivation, doesn't affect manufacturing.
Right.
Just affects the retail. So that one area right there on 5 and 10, I mean, we already approved a site for medical marijuana there already, didn't we? Hasn't been built.
Right.
But
It was a medical marijuana
Yeah.
dispensary.
yeah.
For recreational, I would say planned industrial, which is probably not going to happen because of the federal regs. Who knows? I mean, because of
Right, deed extension.
the deed restriction or whatever. But we don't know that for sure. That's what Paul said. Could be, might not be. I wonder if anybody was here from the planned industrial that could answer that for us. But
You can't right now anyway, because it's 500, within 500 feet of the nursery.
yeah, but I heard it was from, if I understood Adam correctly, it's from the corner of the building to the corner of the building, not property line. Am I correct when I say that? So that's, planned industrial is a viable spot if they're,
Plus, if you talk about the Deerfield Industrial East, that's way far away from.
but regardless, so planned industrial, maybe, maybe not, depending on the bylaws within the planned industrial. So I would say go full industrial, full C2, just be done with it. It's,
For SP.
yeah.
And this is
Yeah,
for
it's all as-
industrial purposes, or which of these categories?
Grow and manufacture and laboratory, right?
Well, retail laboratory and manufacturing.
Okay.
Right?
It's already cultivation.
Well, it's already, we had cultivation specific.
Although not in C2.
The main C2 is up in East Deerfield.
Yes, the C2, it's up at the rail yard.
Right, but there's some C2, like,
There's some
Along
C2
5
just
and
above the industrial, down in south.
Yeah,
mid
C2 is from
Deerfield.
the old
The largest
drive-in
part
down
is up
to,
there,
what, the dog
house.
place, the vet, whatever you want to
Yeah.
call it.
So if we make that, you getting this? So
Not entirely, because there's no consensus.
well, I
so-
think instead of the
So
10,
let's-
the footnote 10 refers to this overlay, but we're kind of saying that we don't want to use the medical marijuana overlay.
Okay, so we're not going to use the medical marijuana overlay at all.
Well, we will for the medical.
Right.
But no, for the recreation, we're not going to
Not
use it
for
at
the
all. We're just going to
recreation.
refer to underlying zoning.
Just
Yeah.
refer to industrial and C2.
So why don't you want to use the medical overlay for,
Because it's so,
Recreation.
such a tiny little.
So restricted.
But the thing is, it's going to end up being the same. In other words, the medical retail facility will automatically become a
Right.
single,
And-
Right.
a single
But that-
retail for marijuana.
We're
That's
not
in industrial, so it still includes it, but it doesn't.
We're not saying don't have
we're not saying don't have it.
recreational in the overlay, but just as far as medical purposes go, just leave that alone, like it never changed. Right? Adam, am I making sense?
We're not, for present purposes,
Right.
we're not eliminating.
But down the road, it probably will have to, and,
Right, and so it becomes more of a drafting issue for me, just so I understand what it is that I'm doing. The way that I've currently structured it, I've reworked the overlay to be sure that it's not referred to as a medical marijuana
Right.
overlay. It's a marijuana overlay.
Right.
And then I've utilized it both by maintaining it in the medical marijuana treatment center section of the bylaw and then adapting it to recreational marijuana.
Right.
It's an easy fix to undo that. I would need to include a provision that allowed for the conversion of medical facilities, although you currently don't have one, but you could in the future and
Yeah.
for the time being, to allow the conversion to a recreational if it's in the overlay, if you're not going to continue to use the overlay for purposes of recreational, and if you're going to rely entirely on the underlying zoning districts for recreational, that's fine. In fact, it just eliminates a whole section.
Right.
And it eliminates section 4664 on page 4 of the bylaw, where I've identified the overlay district, And now I'm simply going to be relying upon 4663, which is going to have to be reworked a bit, because I've got to include the limitation on marijuana retailers up there. But I won't be making reference to the overlay district any longer. And in fact, I can undo some of the changes I've made to the overlay district for medical marijuana, because now I
Let
can
me just
continue to
ask
follow.
another question here, that if, let's say, for instance, we don't have a medical marijuana dispensary, and we get a retail dispensary, it's our one unit. Then somebody comes in and says, I want to put a medical marijuana in there, and it's separate. I mean, then do you have to have two of them?
Yes. Under the current licensing scheme,
So if you
yes.
keep it all together, Carolyn's had her hand
Carolyn
up
knows
patient.
something.
So what you guys are proposing is eliminating the overlay district as restrictive as we all agreed upon before. You are opening this all up to all these new districts. You're expanding
It's
this.
the will of the voter, Carolyn. It's the will of the people.
But what Carolyn is
We're
proposing.
proposing, do you have a comment on that?
Yes, I think we need to keep this contained to the overlay.
And it's that one little strip on
Yes.
5 and 10 across from
Why
Yankee
would you
Candle.
want a retail in all these places?
Well, you get one retail in town. So it's
No,
not gonna
it
be-
is, it's
you could end up
We don't
with two
know
if
that
you
for
change
sure.
it.
We don't know that for sure.
Yeah.
When we went to the MMA conference and we went to the workshop, this was the current thought. But there has been all this regulation and the social consumption thing is up in the air. But because what they said was if you did this percentage of your liquor licenses, then you don't have to have social consumption.
Okay.
But as Adam said, this is draft stuff, and it's really political at the moment. So what you guys are proposing is opening this all up, all over town.
Well, that's not my interpretation. I thought there was a fact that you only had to let one retail in.
No, that's what I just asked Adam, is if you have, let's
Well, no,
say.
you asked
That's what
about
everybody
one
was
medical
telling
and
us.
one-
No, but wait a minute, let me say it again, because if you have one that's the retail for social, for
Right.
personal use,
not
and
social,
then,
but
and you
retail.
don't have the medical one.
Right.
And then somebody comes in and wants to open up a medical one.
Right.
If I understand what was said earlier, that person that opens the medical one has the right then to sell recreational, so you'll have two. And I think that's what it's saying, but I'm not
It's
sure.
kind of a backdoor thing.
Yeah.
But again, it's not, these are draft regulations. They're not, if you have been following this, this is not, I mean, it's fluid. And the governor and everybody else and us, we're complaining. We don't want this social consumption stuff pushed down our throats. But what you guys are proposing is to eliminate it to the overlay district. You're opening it up all over town.
With the current overlay district, somebody could come in, sue us, and we would lose, Carolyn.
No, our overlay district.
It's not big enough.
The Attorney General has already.
Yeah,
approved
the
of our
medical, it
overlay
was.
There's another way to look at
medical.
this, too. I mean, I know that we have some local people here that are interested in the cultivation thing, and we're opening up our entire town to allow this cultivation, which is over 80%. I get it, but just listen to me. So we're talking about making this available not only to the residents that are here, but to anybody that has farmland around. And that there are some, downsides to this. Different people have different opinions on it, whether it be odor or lights or whatever thing. So now, when it comes to the retail, and I share your personal view on this, but why are we picking what property owners can benefit from this?
That's my
Why not?
point.
Just, if you're going to make it fair, just let all the commercial, and let go wherever it's going to
We
be.
discussed this and had the overlay district. We all agreed on the overlay district, what was it, 2 years ago?
And I get that, and I understand, and I agree with that, but it's not a fair way of doing it. And if you're going to open up 80% of our town to let it be grown wherever somebody would choose, why not let whoever wants to sell it be, it's just as fair? I mean, I share your personal opinion that it shouldn't be, but, in a matter of fairness, why only allow certain property owners to benefit from this? Let it be opened up to the entire area.
I think that one of this actually goes back to a comment that Roger made, which is that we do have to decide what it is that we want, the nature of our town. And so
That's
if we're
true.
saying we're actually, in your fairness, bid for like fairer treatment, we're trying to be fairer to our agricultural partners in town, because that's how we identify our town, and that's where we want to kind of set ourselves. And I think in terms of this retail feature, which is, and I'm seeing Carolyn's point of view a little bit more clearly, that if that becomes now a new kind of drama in the world of Deerfield town economics, that doesn't suit what we are looking for as a town character. So I think that the fairness piece of who gets access to this new retail bonanza, that's a tough one, but at the same time, our job is to also consider what sort of town we're living in. And I think that this is a suggestion for us to touch back to what we were thinking at that point, which a lot of it did have to do with, I think, Paul, you're right, it had to do with security, but in point of fact, it also had to do with what's the nature of our town, and where are you going to go in town to do what. And this way, it's just a little bit clearer. And if we decide that we want to bust it open, we have new chances to bust it open further. But this way, we're a little more conservative to start. The impulse to be a little bit broader, I think, is one that actually goes against our nature. To be honest with you, we're conservative. It's a conservative town. So I'm soft to the staying a little bit closer to what we had talked about 3 years ago, sitting, before town meeting, trying to really punch something out that we could stand in front of back when we even knew this was a threat.
Well,
John told us it was a threat.
We still have the chance to opt out.
Well, that's what I was just gonna say, if it's
And that
so
went off the-
unknown, what if we just do the moratorium or just do it outright?
Well, the moratorium makes me nervous, Roger, and I didn't speak up about this last time, but the moratorium, the problem for that is that we're caught in this, we got caught in it with medical, and I think, and I thought we did a good job. I mean, a lot of us were still right here, and we pushed through something, we made it happen in a way that we could live with. I think if we move to a moratorium, we're kind of saying, we can't figure this out, and then we're going to get caught in another cycle of another
Yeah,
sense
but
of.
even the medical part
sense of-
has changed. I've learned, a lot about that, and I don't even know.
And we're learning, I agree. So if we said, moratorium's great because here are the things that we're going to learn, but I think we we're ahead of that. We're ahead of learning everything.
I don't know if we are,
We don't,
because there's
well,
a
we
lot
don't
of-
know. The things we
You're
don't
right,
know,
we
we
don't
don't
know.
know, and
That's
we're
the
not going to know
problem.
until, the moratorium's not necessarily going to help us find that out. It's going to roll
Well,
out.
And the
We're gonna let other
moratorium,
towns experiment,
Well,
I guess, and then we'll find
There's
out
that.
and the
what works or doesn't
moratorium
work.
requires a referendum vote as
No,
well.
I know that, Paul, and that's why it would have to be a ballot question. I remember, no?
Not
The
the
moratorium doesn't?
No, the opt-out.
Okay, the opt-out was because we voted
Oh, I'm
in
sorry
favor
then,
of
I
it.
misunderstood it.
Not a
Opt-out is a
moratorium,
vote.
an opt-out does, a moratorium.
Opt out, okay,
Prohibition.
opt out,
Right,
yeah. okay.
temporary moratorium does not, town meeting vote.
So now we're back to this restrictive area is
Well, I
kind
just,
of,
And it's just one retail store, that's all that's
That's
being restricted, is that one?
No, she says it's unknown, it could
Yeah,
change.
so
That's the current interpretation.
That's changed in the last hour.
I know, that's,
Right?
so that,
It's what-
so let's restrict it,
We're shills is
let's
what we
restrict
are,
it to this
John.
area, sorry, keep the overlay.
That's really,
So we'll keep the overlay, which is restricting.
I mean, Adam
takes
did a
into
good job
consideration-
explaining why we should keep it and stuff, and I thought it made sense. but-
Security and everything.
Yeah.
All right.
Can I ask a question about Alex?
Yep.
Do you know anything about the, because this, part of this overlay includes DDIC, and DDIC is quite a big part, it's actually a bigger part than the other.
Right.
Have you done any research into that? We've only heard from Paul that said DDIC's not gonna allow it because of federal
Now,
regulations.
you should have stated that's Paul
Olszewski.
Olszewski, it's not me.
I know Paul.
Okay.
I'm in DDIC.
No,
Right.
I know, but I don't think people understand when you say Paul. I'm the only Paul in the room right now that I know of.
Olszewski.
Okay, there you go.
Right.
He's the chairman of DDIC. and you're
Right,
the
right, right.
coordinator. But I
Yeah.
had heard that he had said that they're not going to allow it, and then other people said it was a federal regulation. But I didn't know if Adam knew anything, not just about my place, but there's, on the other side, in that Deerfield Industrial East, I mean, there's all those small condominiums, it's all
Yeah,
broken up.
yeah.
I mean, there's a lot of land over there.
Good question. Yep.
So I can answer that in several parts. So first, I've had an opportunity to speak to Paul. I had an opportunity to speak to him prior to the last meeting. So I'm aware of his issue, and obviously he spoke at the last meeting and expressed the same issue that he and I had discussed at length by telephone. I've not been instructed by the town to research the matter. That would require me to look into the organizational documents for DDIC and get a sense as to how it was organized, whether my understanding is that there were certain federal funds maybe used in connection with this organization, whether there were strings attached to those funds with respect to future compliance with federal law. I would have to do title searches on the properties within the district to see if in fact they've got deed restrictions. Ultimately, it doesn't matter for purposes of zoning because all you're doing is allowing a use for zoning purposes. If deed restrictions say the use can't be made of the land, then the use can't be made of the land. There are many individuals, homeowners, who have restrictions on their deed restrictions that have been in existence for 10 years, 20 years, 100 years, that restrict how they can use those properties. Activity and use limitations is a consequence of past contamination that limit how you might utilize a property for things like farming purposes. You could be in an agricultural district that allows you to use your land as farmland, but if you've got an activity and use limitation on it that says you can't dig any deeper than 6 inches, you're not going to be using it as farmland. So the fact that there are restrictions, and there may be, I don't know the answer to the question, I've not researched it, but it doesn't affect it for zoning purposes. The only implication for your board may be in looking at the policy implications of choosing that as a location of your potential uses. If you had a district that was 95% restricted through deed restrictions or otherwise that couldn't be used for the very use that you're allowing there, then are you really allowing it anywhere? That's the policy question. But in terms of a zoning question, it's irrelevant. But I haven't researched it fully.
Thank you. So, all right. So I think we're back close to what we started with, is what I'm hearing. With a, just a footnote to setbacks of 25 feet on the side and rear in the RA, which, so that doesn't probably require a dimensional table then. It would actually match the, what we have in industrial. And then there was some question, do we want the SP for laboratory and manufacturing in the EPD? Because that just came up quickly at the end of the last meeting.
So that would be called a perimeter setback of 25 feet, correct?
Well, it's side and rear, not, the frontage is already more than that, so.
I believe in EPD it's perimeter.
Oh, right, I was talking about.
So, I mean, if you're trying to make the setbacks the same as EPD, then it'd be a perimeter setback. That's why I was saying that.
No, I would say keep the front setback, what's already in our documents.
Yeah, that was 30 feet, right?
And just add the others.
Okay, so it's not the front then.
So then my question was about EPD. My question was, do we want to keep this special permit for the laboratory and manufacturer?
Okay, so it's just side and back setbacks, not the front.
The front's already more than that. Well,
30, if 30 there.
Yeah.
Okay, so it'd just be the rear and the side setbacks
To go
would be
from
25.
10 to 25. Yeah.
Okay, got it.
Match.
Got it.
Well, since the town hasn't paid any principal back on that, it might be nice to get that on the
So we should leave it as a
positive income
Maybe the
stream.
bakery can use a new ingredient.
They'll make the.
How is that bakery coming?
All right, is there any other comments on his draft? Because maybe we're ready for a public hearing.
I had one more comment, which was in regard to the requirement that site plan review be conducted. And typically in section 5400, when we add new uses to it, we add them as a trigger in the beginning of the section. There is an overall section that says, and any other uses that are listed in table 2, but if it's in another section and not in table, in the use table, it might, so this is on page 73. In 79, 73, we have the list of what I typically refer to as the triggers for what site plan review is required for. So that might be a good area to, again, add additional clarity by putting this in as a use specifically.
And what was that again?
It's section 5410 on page 73. It's under site plan review. It's the applicability section.
So what is the difference? What special permit and site plan review? Because we require.
Special permit is discretionary and site plan review is not.
So we would require both of them, but basically special permit would, a lot of the site plan review would come under the special permit.
And in fact, your special permit refers to your site plan review section in terms of what's required to be turned in with the plan.
But special permit is even more our discretion, and site plan is, if they meet it, they get it.
Do we,
Yeah.
do we treat this type of operation as a commercial with our site plan review? Are all the same requirements going to apply?
There you go. Yes, that's what it's residential.
And also, does odor fall into this, Pat?
Change.
Well-
Special permit.
It's
Just
typically reviewed more in the nuisances in regard to special.
Special permit, okay, good.
So I guess that's why Pat's
Yep.
saying call it out specially in
Sure,
this
go
section
ahead.
5400. Does that, to make sure that,
Right.
even if it's in a
I'm
residential
all, whenever I'm
agricultural-
doing zoning bylaw amendments, I'm always trying to think, like, if you're somebody coming into town to make a proposal,
Right.
how do we make it eminently clear what you're required to do?
Yeah.
So I think that would help.
And we did that with the large-scale solar.
We
did
have
it
done
with-
that, yes.
Yeah, so,
Multiple times we have added to this.
all right.
So in CVRD and residential RA, the signage as
Alright.
proposed currently is 3 square feet total area. So that's
Three
Was it
square
three?
That's what it
feet?
is.
So that shouldn't change, right? That's residential signing, that marijuana shouldn't make
Oh,
it
wait,
any
wait, wait,
different?
wait, permanent
What page are
buildings.
you on?
I think you can get two
That's
2x8 signs or one 16 by 16
thought you-
sign.
I swear, I lie.
3,200.
No,
Does that
I don't
sound
lie.
right?
But I
Permanent
thought,
buildings.
I thought in this new proposal it was reduced to 16 feet.
16.
When I
feet.
review the available
6 square
signage,
feet,
Which still isn't that big, that's
right.
2 by.
It's just, if it was consistent with the current signage, signage for RA, CVRD.
You know, looking at this.
We don't have an RA signage?
I think there's
It's-
an argument that this needs
Oh,
to
it's
be
in there.
amended.
It's in there.
Yeah, but when you,
Well, but
when you
in any
refer to
case,
signage,
it's
I'm thinking of
regard-
trying to sell something, and I know like farms are, you know, there's names
Yeah, I
of
know,
farms, and
I
they
know,
might have
that's
it, but
what
they're
I
not
was
really
gonna
trying to
say.
sell anything, it's maybe somewhere located.
Except an
So-
ice cream cone and a,
Right, but you're not selling, it there, you're
They're
just
not selling
raising
it.
it, so
They're just- it
would there
just
be any
says-
need for advertising?
Exactly.
Well, not necessarily advertising, but I think a sign is an essential thing. I mean, they're
Well,
going to
right,
want
if
to
you
no,
delivery and
For
stuff.
truck drivers.
Right, I
Yeah.
understand that, and that's why farms
Doesn't
do
need to
have
be
their
selling.
name out there.
But
So
I,
two signs not over 6 square feet, that's what it says now in 3212, so that sounds good.
Because I don't see a whole lot of signage coming
That's
with
just
the growing. though.
Directional.
Yeah.
just locate it.
Right,
555
yes.
River Road.
I
whatever.
agree.
And then get us-
John, did you say
Yes,
6 square feet?
Yes,
that sounds really small, that
John.
doesn't sound right.
Got it
on
covered.
page 18, 3212. Yes, sir. Yes, hey,
I think you guys ought to really keep the signs for minimum. You don't need a big sign. You usually have like the small balloons for state highways. There's no need to have a big sign in a residential area.
yeah.
Just an address on it, a small name, keep it real.
6 square feet is what's in the zoning, Greg.
Currently.
2 by 3 roughly, what do you think?
Yeah, you don't need, that's even too big.
But that's what's
Okay.
allowed everywhere already, so,
That's in the,
yeah.
so not
But
changing.
that's Central Village, right?
And,
And RA.
And residential. Yep.
Oh, an RA, yeah, okay.
So are we just going to entirely defer to the underlying zoning for purposes of signage?
Thanks.
yeah.
Okay, so if it's in a commercial or industrial or,
Oh, commercial industrial, you get larger signs, you're right.
right, you get whatever's permitted.
Who's there?
They get-
It would
they
be,
get
it would be industrial or plain industrial for a cultivator. Or
That's when you can get the 32 square foot
So
one.
this is,
Yeah, there'd be no need for it, really.
Yeah, I just missed the other one, I saw that.
No, it probably isn't, kid.
Not a commercial area. It's only a sheet of plywood.
Oh, really? So it isn't that big.
I think, yeah.
So what did you have, you suggested something?
Well, I'd suggested something, I missed the first reference in your bylaw to the signs in residential district. I read it too quickly and presume you didn't have signage requirements in residential because most communities
Well,
don't.
it says 6 square
You've
feet.
got it, so that's fine. So we'll
3
mimic-
square
we'll
feet for
mimic things.
residential,
So the question
6
is-
square feet for a, I guess, what is it called?
Industrial,
Permitted.
or the overlay.
For a permitted
Permitted.
structure in a residential, which that would, is what it would be, right?
So
Here are the others.
I can simply modify section 4666 at the bottom of page 5. I'll take out the whole language notwithstanding anything to the contrary and simply say that signage shall comply with the requirements of the underlying zoning district. But I can still proceed to say, if you'd like, that the sign shall be affixed to the building or structure at
Yes.
the premises and shall not be a roof sign. and shall otherwise be in compliance with the more substantive sign provisions relative to lighting and such.
No,
And then,
no indirect
Doesn't say
lighting.
anything
I mean,
like that
no,
here.
that, and no, the signs can't be lit internally.
right, and then I'll continue to reference that marketing and advertising requirements of the licensing regulations apply. And that goes to the point that was made earlier about what you can put on a sign. Can you put, pictures of cannabis, or
Right,
can you
right,
put, other things that would maybe appeal to underage individuals, things like that, which are all restricted by the
So,
regulations.
so planned industrial, that this would limit that as well, right?
To whatever is allowed in planned industrial.
Well, in
right?
planned
Well, actually,
industrial,
that
they're
allows
allowed
32,
more.
so actually, if you could put a top limit of 16 like what you
Yeah,
have, leave that.
they're allowed 2 signs at 32 square feet, from what I read here.
So you could leave your language that you
that's-
have in there,
that's
just say,
pretty- that's pretty
either
good.
the underlying, for RA, we want to keep it whatever it's in our zoning, but for industrial, we want it to be smaller than the 32 that's allowed. Right?
Yeah, I would say you're getting 64 square feet if you follow the lighting for planned industrial. But then again, we may not even get anything there.
Okay, yep, another point?
Can you put that in as part of the special permit process for signage? That way you can really get control over it?
Yeah, I'm sure everything's in special permit, so.
That way you can just simple.
Well, but basically what the special permit says is to fit with the character of the neighborhood. But by putting some numbers here, it helps also, it makes people know that they're not going to get a big sign. So, but yeah, we can also do it there.
When you have special permit, then you don't worry about people putting marijuana, cannabis, it's control.
Right.
So you might want to consider that.
Yep.
So,
Why would you want Adam's language? Because he did the research.
Because his language allows bigger signs than what we want in the RA district.
okay.
So the RA allows a small sign, that's what we want to stick to.
Okay.
But then we want to keep his smaller sign for the industrial overlay district.
and so I can do that, but I do want to do a bit of additional research. So a point that Pat just sort of whispered to me was, concern about content based restrictions on signs, which have been prohibited as contrary to the First Amendment.
But
I've got
regulations are going to say something about that, right?
Well, the regulations are going to govern the content to some extent. I have a bit of a concern with the concept of allowing traditional commercial or industrial uses to install signs that are 32 square feet, but limiting signs for these type of facilities to only 16 as a maximum.
I see.
Does that equate to content? Why are you distinguishing between signage for marijuana establishments and signage for widget factories?
Well, you might have the widget sign factories with the widgets on them. Do you want to have the marijuana plants on there and the?
You can't-
That's not allowed under the
Right, so
regulations.
I'm not talking about the pictures and such.
But I also would question after reading it here, is that planned industrial is probably going to be out of question anyway, so does it make a difference?
But no, we're talking about the overlay district that's on 5 and 10 across from Yankee Candle. What, if a person went there?
Yeah, Paul did us a big favor.
We don't want a
by
big
bringing that up.
marijuana sign, right? Is that what we're saying? That's where we're zoning, that's where we're pushing anybody to go. To
But
do a
that's
manufacturing
in-
or a retail, right?
Isn't that industrial, not planned industrial?
It's industrial.
So we're not talking, it does not say 32 feet for industrial.
Yes,
It
the
only
same
says
for
planned
industrial and
industrial,
PI.
doesn't it?
It's I and
Did I
PI.
read it wrong?
Commercial industrial district. plan.
Oh, it says industrial, I'm
3222
sorry.
on
No,
page
commer-
19.
Oh, I see the, yeah,
Commercial,
okay,
industrial,
yep, I'm sorry,
planning.
I'm sorry, I understand now. I misread that, I didn't see it, I saw IP, but I didn't see I, and it's written out in words.
It does, see, this is one place where
Yeah.
we failed when we changed the
C3 is
C3 to I. It's now I, but we failed to fix that in this
Yeah,
bylaw in this
okay, all right.
location.
Okay, well, that's what I was looking
All
for,
right,
was
so
I,
you
and
got
I
that,
didn't see
Em?
it.
I do. So are we going to attempt to limit to 16 square feet signage in the I and PI, or are we going to just defer entirely to underlying zoning?
I think you have to go with underlying zoning. You're-
I don't want, we don't going to get sued here for free speech.
Yeah, I think
No,
we,
it's,
you defer
I
to
mean,
underlining zoning.
what's it meant, it really.
Doesn't matter.
Dr. Hushka?
But the only place that it's going to be able to get sold recreationally is in our overlay district.
Right.
Okay, because when you were talking about the industrial over on 5 and 10, you referenced both, and I just want to
Yeah,
make sure.
no, that's out again.
Okay, it was just a mistake.
Sneaking back in.
So we're going on 3 hours, and I think we're there. So we haven't changed this very much.
No, basically, you're back to exactly where you started.
Well, you're close. So one thing that Pat had referenced, and I mentioned before that I didn't make too many substantive modifications, certainly no additions to the medical marijuana treatment center bylaw, previously the medical marijuana overlay district bylaw. But she mentioned a transferability provision, and whether it made sense to include that if we're preserving that bylaw. And I guess I've got the same question, not to overly complicate things, but we've started talking about dimensional requirements. I guess those have been focused more on the cultivation. We've talked about the signage requirements. I guess now we've talked about maintaining the underlying district, which is what the overlay district already does. So never mind. I guess those have both been addressed through our discussions tonight.
Yeah.
But do we want to add a transferability provision similar to what I'm proposing for the recreational
Yes.
marijuana?
I would say yes. I'm surprised we didn't, yeah.
Yes.
Okay. So that's fine. I can simply
Yes.
mimic what I've already got and just add it to that section as well, a section that my guess is we'll be
Go away, yeah.
eliminating in a year
Exactly.
anyway.
Right. But it
Okay.
just kind of protects us against that little,
In the interim,
yeah.
right. Okay.
All right, so there is a little neatening up to do, so we'll see this again on March, at our next meeting?
Yeah.
Yep.
And then we can
And
have
I think it'll be, I think, given the nature of the changes, that it will be in good shape then for you to
minute
vote it and set your public hearing.
and then we can do the notice of public hearing for
Yes.
the, and so we'd probably be looking
According
at,
to this new timeline, so we'd be looking
The
at a public
26th of
hearing
March.
around the 26th of March.
But we don't want to include the C2 district way up in East Deerfield. Okay, I just,
no, we
okay.
left it the overlay.
And then
a good reason.
the only place that can be sold is in our overlay district, because we
Yeah.
don't know if we can only have one store or multiple stores.
Right.
I'd like to add, and I know it's getting late, so I'll be quick.
Oh.
I think that the legislation is somewhat clearer than has been represented, and I just want to be sure that my position on it is known. The language, and this is all fluid, so everything that we've said tonight is subject to change. All legislation is, particularly when it's new legislation and when the regulations are still in progress and haven't been formalized yet. I do think the language is quite clear that you're limited with respect to retail operations. The number of marijuana retailers equals or exceeds 20% of the number of licenses issued within the town for the retail sale of alcoholic beverages not to be drunk on the premises pursuant to Chapter 138. That is an express limitation. I think where the confusion lies is not in that phrase, because if it were simply that, we would say, you're limited to one and we're good to go. The question becomes, well, now the regulations have introduced this concept of a social consumption establishment. And is that a type of retail establishment? And do you have to prohibit that only through an opt-out process requiring a referendum vote? And if you don't prohibit that, does that count toward this 20%, or can those be above and beyond? And what about these mixed uses, these lounges or clubs where they might also provide? So those are the questions that exist. It's not so much the plain language of the legislation, it's whether these other uses, this other terminology that they've now built into the regulations has opened the door to the possibility that someone's going to make an end run around this 20% limitation. I think we'll probably have an answer to that relatively soon, maybe as soon as when these regulations are codified, before you have your public hearing.
Yeah.
Okay, good.
But as long as we have the medical marijuana, then they have the first rights to be the retail for the recreational.
Right, I mean, when you start then talking about the interplay between medical and recreational, now you confuse things even more, because yes, they have first dibs on licensing in terms of licensing from the state, if you have one that's in existence. And then, separate and apart from that, the fact that you're operating at least until December 31st of 2018, you're operating or you seek licensure as an RMD, or registered marijuana dispensary, which is a term under the medical framework. You could then be dispensing medical marijuana, and that establishment doesn't count toward the 20%, because that's a medical-only establishment with individuals who have cards. So that wouldn't count toward your 20% cap, because that's not a retail store.
Yeah.
It's a dispensary under the medical legislation.
Pharmacy.
But I also heard somewhere that the medical marijuana dispensary is just that, but they also get the right to be the retail for the recreational. Is that
They're
not
a priority applicant. Like you said, they have first
but they've got to go
dibs.
through the
They still have to go.
licensing process. And if they go through the licensing process and they obtain a retail license as a quote-unquote marijuana retailer, well, then that's your 20%.
That's your one.
Okay, all right.
Carolyn?
I just want to say that we can expand the district, we can expand
Yeah.
retail, should we want.
Yeah.
But the idea is to be very conservative and to, contain it as much as possible until we know what the impact is on our town. I mean, that was the whole point of having the medical marijuana overlay district to begin with.
Okay, we got it, thank you.
I pushed you guys to do this.
Good.
Thanks, Carol.
Can I ask one other question here, is about the tax? Is
Yeah, I
that
was just
something
gonna ask
that
that
comes
tax,
from
yeah.
zoning, or is that the select board gonna put something on the warrant about the 3%?
The select board does.
All right. Anything else that zoning should be aware of on
Nothing else
this?
for zoning. We're in talks about things like taxation, about
Yeah.
a licensing process locally that
Yeah.
would give you better enforcement. So those are non-zoning issues that need to be addressed, should be addressed.
So this is going to be one of our options on a ballot question, these regulations.
Not a ballot question, a town meeting vote.
No, because I thought we talked about it. I thought it was at we were going to do it because if we wanted to opt out, that we would have to have it had to be a vote if we wanted to not have any of it.
Yes. That
So
has
it'd
be a
have to
vote.
be a ballot question. And I thought we're going to put all three because some people don't go to town meeting, and to have more people have their voice heard, it would have to be on a ballot question. I've had people tell me that they'd like to see it on a ballot question
What,
because.
the zoning? They want it on the ballot?
The opt-out.
Yes,
The
Well,
opt-out
all
part,
three
don't
would
they?
be there.
So you have the option.
Yeah, it would
Well,
have
somebody's
to-
gonna have to write the article and get the signatures,
Yeah,
because the
that's not a
select board
planning board.
already made it very clear that they're not
Well, I don't
gonna
know,
put it on.
maybe they've changed their mind, maybe, and if they don't want to do it, we'll have to do that, I
Well,
guess.
yeah, right.
All right.
So
But
you're
we're
still
taking
not,
care-
you're
But
still
that's
not willing to
different
put that
than
on the
moratorium.
warrant?
Are you willing to let the selectmen do
We'll do our 40 signatures.
But that's different than moratorium.
What's that? No, yeah, it is.
I mean, I think that, I'd love to see us just walk by the moratorium. I think we did a lot of work before with medical marijuana.
Well, I've learned a lot since the whole process started,
Yeah.
Rachel, and I've changed my opinion. I said
Yeah,
I
yeah,
voted
yeah.
for it, and so I think there's a lot of people that maybe have, and Julie was here and she voted no, I guess, and I said, well, maybe she was smart, she understood it better than I did.
Yeah.
But I think maybe a lot of people have changed their mind, and so maybe we need to
But
give
that's,
them.
I mean, I'm hearing you, but that's the opt-out, not the moratorium.
No, yes,
That's what we're
opt-out, but
understanding,
you
yes.
could put all
No,
three
no,
of
those
them
are two
on
different
there.
things, though.
No, I understand.
Right.
But you don't think this restrictive zoning gets at a lot of what
I just,
the issues
I
are?
think opt-out more.
I don't think so, really, John.
From one,
But that's just my opinion, that's why there's
The
seven of us.
The RA part sinks the whole thing.
for cultivation.
No, yes.
But a lot of people don't want it all over the community,
Yeah.
you know, in
The
our whole
cultivation.
town.
Right. That's what's.
But it doesn't have to be, because we
I know,
have to get a
but that's
special
what we're-
permit from this board, and so
No,
if you're
it-
here and you say it doesn't fit into the character of that neighborhood, then you don't,
Well, I don't
get
know
it.
if that's
having
gonna
it-
work.
Having it possible in RA sinks the whole thing.
Things I don't understand, and it's now near the end. I asked for
What do you-
people's
what's
opinions.
Well,
unclear
it's,
about
10 o'clock.
RA is
But
unacceptable?
I thought we were gonna get the regulations, and I thought it was, where the town was gonna get to vote on if they accepted these regulations, whether they wanted a moratorium, or if they wanted a total, you know, out.
So can I just, a moratorium, if you were proposing a moratorium, that would be in order to do what?
Because everybody, Carolyn, you know, 1 minute we can have one, but we're not really certain. Adam just spoke to that, about the liquor licenses, and he feels pretty confident that it's gonna be just the one. But it's still in limbo, like, and.
But the fact is, here's an interesting thing. So if we, even if we did that, then we would, if it changes, we can still change what we have. I guess I'm saying
guess you
moratorium
could.
is different. Opt-out I get, and legislation I get. It's just the moratorium I'm not, so I feel like if you could clarify
Well,
that.
there's some
that-
towns
no?
that are chose just not to have it in their community. And you
No, but
spoke
that's what
on
I'm
it,
saying,
the
opt out.
character of our, yeah.
But that's different than moratorium. Moratorium is putting off. It's like
Right.
deferring
You're buying some
it.
time to see.
Postponing it.
Yes, I understand that. And there's a lot of communities that did that. They're buying time, and Deerfield wouldn't be the guinea pig, it'd be
Somebody
whatever
else.
town, you know, and we'd look
yeah.
at maybe what mistakes they
Yeah,
made
yeah,
or
yeah,
what.
yeah, okay.
So my understanding is that the planning board, we took care of the zoning
Yeah.
bylaw
Yeah,
part of it.
that's
All
right, but everybody's gonna approve this at,
Town meeting.
well, not
Well-
necessarily town meeting, it can be a town meeting.
No, it can't be.
Well, the zoning will be town meeting.
Zoning is
Right,
down.
has to be
yes,
done.
right, it could be,
Zoning would be, but the more referendum
Right.
has to be at a bigger election.
right.
Anything else?
I mean, Adam, is that correct?
So there's a difference between putting a question to the voters via a referendum and voting on a bylaw of this sort. Bylaws are not put to voters at a referendum, never. There's no mechanism for doing so. Questions are put to voters at a referendum. So the question to the voters, if you wanted to present it to them, would be an opt-out question. That's the only question that would need to go to voters under the current legislation. Do you wish to opt out of, and you could list specific types of facilities, all marijuana establishments? That would be the question that would go to the voters, and it would need to be accompanied by a bylaw to that effect that imposed those prohibitions. The referendum vote authorizes the prohibition, and the bylaw puts into effect the prohibition. That's option one. Option two is what we've done tonight, or what we've started doing, continue doing tonight, which is you craft a zoning bylaw that provides for regulation of the use, but is not outright prohibiting any type of the use. That doesn't go to the voters. There's no mechanism for it to go to the voters, except that it goes to the voters at town meeting if they opt to attend town meeting and they have an opportunity to vote on the article. Because there's no opt-out part. You've not restricted, you've not prohibited any type of marijuana establishment as part of the proposal that was before you tonight. The third option, again, entirely separate from 1 and 2, is the moratorium option, which once again is not put to the voters at a referendum. A moratorium is something that is adopted at town meeting by a town meeting vote and is for a limited period of time and simply restricts. It's the same thing as the opt-out, but it's just for a limited period of time while the town is undergoing a planning process to put appropriate zoning in place. Those are the three options. And you can, we talked about pursuing a couple of them if that was the will of the board. We just need, it's a balancing act. You got to be sure that the appropriate articles are on the town meeting warrant in the appropriate order. And you've also got to be sure that to the extent that any one of those articles requires an accompanying referendum vote, that plan has been made to, so the question is on the ballot that goes to the voters.
Okay, so to clarify it then if, say, Roger or somebody that supported what he was talking about went out and got a signed petition, then he would turn that in and it would be on the May 1st or whatever date we have our elections? And is that what the referendum would be that time?
There'd be a request for a referendum, and there'd also be a proposed bylaw that put into effect the prohibition of the use.
Does that make sense?
I understand what he's saying.
No, I was just trying to see if,
But
if
by
that's what you
putting our
wanted.
proposed zoning at town meeting, and correct me if I'm wrong, but I think if you don't change it drastically, motions can be made from the floor that could change these regulations, because there's discussion, and so somebody could make a motion at town meeting that they wanted to change this in some manner. Maybe they wanted to have the industrial zone as where they could sell marijuana, or the people that are going to be in charge of the special permit process may be not who we suggested. It could be somebody else. Am I right or wrong?
There's always a possibility for floor amendments. If there's a motion and there's a second, then it becomes a question for the moderator as to whether or not it's within the scope of the article as advertised.
Right. So,
some may be, some may not be, and
so
I'll
this
defer
could
to the
get
moderator in
changed
that regard.
at town meeting if it was a ballot question. It wouldn't.
All right.
Yeah, okay, but I was trying to get clear for you that.
I understand what you're
Okay,
saying.
all right, you're fine. Okay.
Thank you very much. Sure. So we'll see, you could get something to us in advance of the,
Yeah, these are simple, so I'll certainly get something to you in
all
advance.
right. And then, so we propose March 5th is our next meeting. It's the
5th.
first Monday of March. There's no holiday.
March
no thing.
5th, yep.
Got it.
7 o'clock or earlier?
No, 7 o'clock. It's a regular planning board
Oh,
meeting. And this will be one of the old business.
Okay.
Motion to adjourn?
Thank you for
What's that?
attending. I need one other announcement. Thank you for everybody attending. I need approval to pay FERCog for Pat's work back from last July to December. It's 6 months' work, 49 hours, $3,000 some odd dollars.
I'd like to make a motion to accept the bill and pay
Hey,
it.
I second.
All those in favor?
Aye.
Thank you. Any other business before us?
There was some mail about a vape shop in Whately, really, 3 State
Gay.
Road, George Gay's place. Motion to adjourn?
I second.
A bait shop,
Aye.
John?
Favor, aye. John, we're up to here.